Don't worry about it. We can take it as corrected.
This appeal hearing is in regards to CA 012-2021 before Chief Justice Zaki Azmi, His Excellency Justice Shamlan Sawalehi, and Justice Robert French. The applicants are represented by ANOMA FCE. Lead counsel is Mr. Stephen Thompson, KC. The respondents are represented by Clifford Chance, LLP. Lead counsel is Ms. Annalise Day, KC.
Yes, Mr. Thompson, you are now a KC from a QC.
That's right. I did nothing at all to change, but I think Ms. Day and I have both been redesignated. Good morning, good afternoon to your lordships. There are two appeals which I think are going to engage us today and tomorrow. And subject to your lordships, the way the parties have agreed to split the time is to deal with my appeals, that is to say the appeals of Nest Investments and the other claimants today. That's an appeal in relation to a limitation point, and to deal tomorrow with my friend Miss Day's appeal, which is in, as she acts for Deloitte and Touche, and the appeal there is in relation to the question of recoverability of damages as a matter of principle. So subject to your lordships, that's how we intend to split the time. As therefore I'm going to be opening, I will spend a little bit of time, hopefully not an excessive amount of time, just dealing with some sort of common points that are factors to both, which might, if your lordships indulge me, mean that my opening is longer than otherwise it would be to cover those points. But hopefully there will be a...
Okay, Mr. Thompson, before you proceed, am I to understand that if you don't succeed on the limitation point, the issue of recovery does not arise? Yes.
I think that's probably right. Yes.
Okay, that's all right. Secondly, how long do you expect today you expect to submit today?
Well, I'm sure that we'll take a full court day to deal with the issues on limitation.
A full court day is how many hours? You see, Mr. Justice French and we are 3 p.m. now.
Yes.
Mr. Shamlan, Justice Shamlan is 11 a.m.
Yes. No, I understand. We're obviously very conscious of the time difference in this case. I do think probably both issues, both appeals, are likely to take a full court day of court time. By which I mean 5 hours of talking, with whatever breaks then have to be added in. I mean, normally I would say to your lordships that's in the region of 6.5 hours on a clock. But I'm conscious that obviously takes you through to, well, I guess that's 9:30 in Malaysia and Perth.
6.5 hours. Yes, it's 9:30, 9:30. Oh, I mean I just Miss Day, do you agree to that? How many hours would you think you take, Mr. Thompson?
Well,
3 hours, 2 hours, 3 hours, 4 hours?
No, I think my opening today will be just shy of 3 hours, or might be my appeal. Insofar as you want to hear from me on reply, it's always a bit hard to say, but I would try and keep that very limited. I doubt there'll be that much to say on reply.
3 hours for you. You have a more daunting task than the respondent.
Yes,
Mr. Day, Miss Day.
Just to be clear, my lord, I say that conscious that it sounds as if that's more than my allocated share, but I certainly, as a result of the opening, would not expect to take that length of time tomorrow.
Okay. Then tomorrow, I better warn you, we have another hearing, a very urgent hearing that we are going to start, I think tomorrow at 1:30 or something like that. So we have to decide at the end of today when your case will be continued, at what time we'll be continuing your case tomorrow, or the other appeal tomorrow.
1:30 Dubai time or 1:30 Malaysian time?
Malaysia time, sorry.
Yeah,
Malaysia time, that is 9:30 Dubai.
Fortunately,
Mr. French, Justice French and we have the same time zone, fortunately.
Yes.
So it's easier, a bit easier to work out.
that is a little bit easier. But just to be clear, I think the registry informed us that they would be starting tomorrow at noon Dubai time.
Yes.
So that would allow, would it, an hour and a half for your urgent?
4 p.m. Malaysian time.
Oh, 4 p.m. Malaysian time. Would that
But
be
we have,
sufficient?
we have to hear the other appeal earlier. I think 1:30 Malaysian
Is
time.
that likely to be more than 2.5 hours?
No. I think we should be able to complete that 2 to 3 hours. I think we should be able to complete that before 4 p.m. Well before 4 p.m.
Well, subject to anything Ms. Day says, and she may have a different view, I haven't discussed it with her, I would imagine that tomorrow would in any event be shorter than today for us, but she may disagree.
Are you in England, London?
Yes.
So you are what, 7 a.m. now? 8 a.m.?
It's 8 a.m. now.
Yeah. And so, Miss Day, you are also in England?
I am indeed. I'm in London.
Good. So what do you have to say to what Mr. Thompson has said as far as time is concerned?
Well, certainly we'd understood from the invitation from the court that we had 5 hours in total today, not 6.5. Obviously, completely in your hands as to how long you wish to take, but we would understand the court to have read the material in the appeal. We say the issues are relatively focused and limited, and I hope Mr. Thompson can make his submissions perhaps briefer than 3 hours, but I'm entirely in the court's hands as to how you wish to split the time. We obviously say that that this appeal should be dismissed quite shortly, so I can tailor my submissions around that. You're also completely correct that if you decide that the appeal on limitation fails, we don't have tomorrow, because the recoverability appeal only arises if we lose on limitation.
So okay, let's see what happens. And that balance position is always more difficult than respondent, as usual, more often than not. So let's hear what Mr. Thompson has to say, and then we'll play by ear. And okay, if we have to drag on to it, I think Mr. Justice French has also indicated that he doesn't mind, and if I have to drag on, so be it. I'm not in Kuala Lumpur. I'm at a university 5 hours, 4 or 5 hours from Kuala Lumpur. I came here for the convocation. So I'm here, we just finished this morning. So I'm here until, well, whatever time we need to tonight. So
thank you. That's extremely helpful, my lord. I mean, I don't know. There was some debate, but I don't know whether we have transcribers today, and whether we do or we don't, whether you have any preference as to how we might break during the course of the hearing. I know dealing with things on screen has proven to be tiring. So
no, I will, now it's 3 o'clock. Let's go and so for 1.5 hours, 2 hours, see how it is like.
Okay.
And we may take a short break, toilet break for us old people. We need to go there quite often. So so if you need to, then we just take a 10 minutes break and then we come back again.
Of course.
Okay.
All right. I will take it as speedily as I can. I'm conscious of the time.
Thank you very much.
I'm also conscious that at least some of the justices have heard some aspects of this case previously, although maybe not in the recent past to any detail. The substance of the case, can I just outline the substance of the case and point to some salient aspects? It's a claim made by now 10 claimants who formerly owned something in the region of a quarter of a Lebanese bank called in the papers LCB, Lebanese Canadian Bank. Unbeknownst to the claimants, it seems that about 10 years ago or so, the LCB was involved, or at least complicit, in facilitating money laundering and terrorist financing for Hezbollah by virtue of some of the activities of its clients. And the US Financial Crimes Enforcement Network issued a notice about that activity in February 2011. The result of that notice was dramatic and speedy. LCB was effectively then prevented from operating on the international market because it couldn't trade in dollars. And LCB then went into liquidation. Its assets and liabilities were sold en bloc to another bank, Société Générale Banque de Liban, in 2011 as well. So by the time you get to the end of 2011, the shares formerly owned by the claimants were entirely worthless, having previously been worth hundreds of millions of dollars. Now, Deloitte, the famous accountants, were involved as the auditor. There is an entity called Deloitte Touche Lebanon, which was contracted by LCB and retained as the auditor. And unsurprisingly, it was under the usual laws and rules that govern international auditing across the world, incorporated, of course, into Lebanese law. The allegation, the central allegation in this case, which for the purposes of the preliminary trial we're here engaged in or appealing from, is that DTL, Deloitte Touche Lebanon, failed to spot, report and bring to the attention of the authorities that money laundering and terrorist financing activity, or any of the signs thereof, something which the claimants say they patently ought to have been aware of and ought to have taken steps to report up. The defendants are firstly a Cypriot company that operates as the network of Deloitte and Touche offices in the Middle East, including in Lebanon. That's the first defendant, and an individual who was the main leader in the Lebanese organization, effectively in control of the auditing function for LCB. Now, the first defendant is a Cypriot company, as I say. Its failures, the failures of the Lebanese auditing arm are to be attributed to the first defendant and were effectively carried out by or committed by the second defendant. That is the way in which the claim is structured. You will understand from that the claim is not brought in contract, because none of the claimants as shareholders had contracts with the defendants. It is brought in tort, or as it's all in Lebanese law, it's now understood, now accepted, it is brought in delict. So that claim was issued in July 2016, and I needn't take you, I think, to the procedural chronology, but in case your lordships are interested to see it, there is an appendix showing that at bundle 2, tab 25, page 6.
Can you give me the page straight away so that I can punch the page number? It goes straight to that page.
I'm not going to ask you to look at this, but it's page 642.
Okay.
So I'll just leave that for your reference in case it's necessary later. What I do want you to look at is the particulars of claim, and that is at page 20. It starts at page 189. Now, this is, I think, the current version of it. There's a draft amended version, but I'm going to look at this one for present purposes. And I just want to show you the critical allegations of duty, breach and loss as they are pleaded. Now, if your lordships pick it up first at page 206, so unless you tell me otherwise, in light of what you've said, Chief Justice, I will just refer to the page numbers. But if anybody wants tabs or volumes, please say now. Otherwise, I should
my problem is I can't access that. I keep on pressing the number, find page. It doesn't go to that page. I don't know what's wrong. Anyway, so I don't know how you're going to do that. I got here index 13 to 14, index to. I don't know how do you go to.
I think CJ, you put a find page, then you put a letter before the 206.
Oh, okay. What letter is that?
Should be, I think.
02, is it? Because the first one is 01, second one is 02. There two, on the left screen of the page.
You put find, then find
your
page.
left screen there. This is the number I'm looking at. Can you see? Yeah, are you seeing the same page?
Yes. I too struggle sometimes with case lines, I have to admit.
Before the page number, we're supposed to put insert the bundle reference, which is either A or B.
Oh, I see. File A, 1A, is it? 1A.
2A.
File 1A. 1A and then page number. Is that it?
A206, I believe.
It's 206, but I'm not sure if that's the right bundle number for this, or is it just 02? Always defeats me. Oh, so if you type
registrar,
zero,
Shala, can you help us?
I think I've got it. Is if you type in, just try 02-206.
Okay, 02. Okay, that's the second bundle.
02 dash.
So that's not the same page number.
Yeah, you're right. 02-206.
Except that all the page numbers are different. So it's 02-214.
Okay, let's go. Let's go.
So I hope you have there. Did that work, Chief Justice?
Yeah, never mind. Just go ahead. I'll get it.
All right. So what I'm looking at first are paragraph 66 to 68 of the particulars of claim. And these set out under a heading relevant applicable laws and context in the claim, the obligations which we say DTL and the second defendant came under. And so if you just cast your eye over 66 to 68, you can see that there are specific allegations of oversight, including regulations and circulars of instructions issued by the Lebanese Central Bank. That's paragraph 66. And in 67, a duty to confirm the adequacy of the anti-money laundering and counter-terrorism financing policies, controls and compliance in the form of written reports. And the reporting, importantly at 67.2, the reporting of any breaches to BDL, that's the central bank, and the disclosure of findings. And the allegation at 68 is that the DTL and second defendant failed to discharge those obligations. So that's the core of the allegations. I'm going to take you briefly to what the allegations were, but can we first go to what I call page 210, but you will call 216, I'm guessing.
You read the page number on the right top right-hand corner. Master and current, it says there.
Yes, it's
there? It's 02 something.
02-218.
Okay.
And this is paragraph 90, the legal basis for the claim. And you can see that the claimants there pursue their claim on the basis of Lebanese law, and they pursue a claim that DTL and the second defendant breached obligations they owe to the claimants under articles 1, 2, 2 to 4 of the Lebanese Code of Obligations and Contracts, and articles 172 to 8 of the Lebanese Code of Commerce, and under anti-money laundering provisions. Those two blocks of articles are the ones that are going to detain us today, and which I will take some time looking at in more detail. Just for completeness, can I take you to your page 283? Now that page is an annex which sets out the relevant statutory obligations under Lebanese law. And you can see, just again, casting your eye down it, the money laundering regulations, unsurprisingly, unlike many other countries, all date from around the turn of the millennium, the turn of the century, 2000 and 2001, over page 2004. And these are all circulars which amount to legal regulations and money laundering regulations themselves, which we say bound the auditors to conduct certain duties. So you can see, for example, in paragraph 1, in the italicized section, the quote, institutions enumerated in Article 2 in performing electronic banking and financing operations must request that their external auditors, so it's a requirement on the external auditor, and more clearly on paragraph 2, the second sentence, under Article 14 of Circular 77, external auditors were obliged to submit annual reports, and so on. So what you see, and we'll come back to this in more detail, is that around this time there were onerous obligations which were placed upon auditors in order to combat the evil of terrorism financing and money laundering through these additional functions which were given to the auditors at the time. Now, I think then I need to take you back just to finish this point to page 222. It will be on yours. Check that. At paragraph 99, these are the allegations of breach. And what you see here at paragraph 99 is that the DTL and second defendant failed by acting on a mission to comply with the duties under three separate sets of obligations: the Lebanese Code of Obligations and Contracts, the Code of Commerce, and the Anti-Money Laundering provisions. And you'll see then over the next paragraph, the intentional and unintentional failures by DTL and the second defendant, as described in that paragraph, to comply with their duties constitute foot, which the claimants will describe as faults under those three statutes. There then follow over the page from paragraph 101, some 40 odd pages of particulars of how those duties were breached. And it goes into some particular detail about the sequence of events and what it was that DTL and the second defendant failed to do in respect of their auditing activities. And you can just scroll through it and see that that is set out in some detail over time, dealing with events from in the latter part of that decade. The consequences are then pleaded in paragraph 310, which is at page 273 of the master bundle. And paragraph 310 says DTL and the second defendant failed to satisfy the most basic obligations on an auditor to inform the shareholders of the true and accurate position of the audited company. DTL's and the second defendant's AML and CTF audit opinions and the audits of LCB's financial statements allowed the management of the bank to continue their wrongful actions without meaningful reform or exposure to regulatory intervention. And the result, it says in 310, of the misconduct was to enable, facilitate and cause or permit LCB's management to undertake related party transactions without approval. The next subparagraph, to cause material omissions to be made to the recoverability of a subsidiary's lending, LCBIH as a subsidiary. And paragraph 3, to enable and facilitate, cause or permit tabadul, which you will see it's a I think a subsidiary, and there was trading which continued there that shouldn't have been. And then the next subparagraph, enable, facilitate, cause or permit the management to operate LCB illegally, as specified in the US Financial Crimes Enforcement Network notice. So those are the allegations. Go over the page, but it says at 314, but for the defendant's misconduct, the claimants will say that the claimants would have had the opportunity to take action to correct the failures. So if these things had been identified, spotted and brought up and reported, the claimants themselves as a significant minority shareholder would have been able to take action to correct it. And we also say that but for the misconduct, the assets wouldn't have been sold to Société Générale, SocGen, Banque de Lebanon, and it would have continued to grow. And effectively, it wouldn't have been a failed business, it would have been salvaged. At 315, but for the defendant's misconduct, therefore, the claimants would, at the date of these particular claim, have retained a valuable shareholding and continue to receive dividends. So that is the way in which the duties, breaches, and losses are pleaded out. The issues then for trial will be what are the duties on an auditor in relation to these functions? What is the extent of their obligations in particular in relation to anti-money laundering and the financing of terrorism? And how effective were they in complying with them, if at all? And what is the loss that then flows from that? The judge below, first Judicial Officer Bahar Al-Mahari, and then Justice Cook, directed a trial of 3 preliminary issues. Let me just identify those for you. It's in a different bundle, bundle 1. And now I'm going to have to take life into my own hands, find the right page. I think I'm going to guess.
Is it 01?
01, I hope. That doesn't seem to work. I'm going to try 02 again. No.
01?
It's set out in the judgment, isn't it? At paragraphs, pages, paragraph 14.
Yeah,
sorry, 13.
No, thank you, my lord. Let's do it from there. It's probably easier. So, paragraph 13 of the judgment. I don't know if your lordships have the judgment loose. If not, we'll be thrown back to the bundle. Try and find the right page.
I'm looking at hard copy.
What paragraph of the judgment?
13.
1-3. Okay.
1-3 are the preliminary issues they're set out. And you can see that issue 1 is the claimant's claim for loss recoverable under Lebanese law. That's the topic which my own friend may or may not be dealing with tomorrow.
It's the reflexive loss topic, is it?
Yes, I think she bristles at the term reflective loss, but yes, recoverability or reflective loss, call it what you will, something of that nature, which the learned judge found in our favour below. And issue 2, which is the one we're dealing with today, which is limitation. There are 3 sub-issues under limitation, A, B, and C, listed out in Justice Field's judgment. A is not under appeal. We are content to accept the judge's finding that it's Lebanese law that governs the question of limitation. That was a live issue below, but is not under appeal. The judge, as you know, had live evidence from 2 experts, and they both dealt with both issue 1 and both issue 3. For completeness, issue 3, which is about admissibility, was a pure point of procedure, which has also been resolved and from which there is no appeal and needn't trouble us. Now, as we're in the judgment, can I just navigate through the judgment just to show you the structure of it? I'm sure you've had a look at it, but some couple of points I want to make before descending to
Mr. Thompson, just before you do, can I ask whether the debate reduces to the constructional questions about, first of all, when a claim is due under for the purposes of Article 348.
Not longer than that.
Sorry, I don't know whether it was just me, but I didn't hear any words after 348. Is that just me?
If you want, I can hang on, I'll listen to this.
Mr. Abbott not on mute. That might be the problem. Sorry, my lord, I didn't hear the end of your question. Is it just me, or is sounds like
I can't hear him either, just to confirm. I think there's an issue with the connection. Yeah.
Justice French, I think we're having an issue with the connection to you, if you can hear me.
Let me try and call him. He's in Perth. His phone is off.
Yes, I can hear what is being said.
We can't hear you. We can't hear you.
Perhaps we better continue rather than the delay things and let Mr. Thompson get on with it.
Okay, Mr. Thompson, you can continue. He says continue. He'll try to join in later.
Okay,
I
well,
don't know whether that would be. I hope somebody doesn't come and complain that you're not going through the hearing and therefore is quorum failure or something like that.
well, I think, I mean, if I understood correctly, and I admit I was eavesdropping on your phone call, it sounds as if the learned judge can hear us. We just can't hear him.
Yes.
That is right. I can't imagine at this point of proceedings
Okay.
it could be much
Then go
complaint.
ahead. Go ahead. Yes. He's smiling, so that's true. He's smiling.
Well,
That's correct. So just continue. He can listen, can hear us, but we cannot hear him.
Well, in the maybe hopeful idea that I understood his question, I think the point I may have been asked about was whether the issue boils down just to the question of when the limitation period starts. That there are two aspects of limitation which are going to be addressed today. One is what is called in the various scales and arguments the scope of Article 178, whether Article 178 is an article which is broad enough to cover any possible claim that anybody could ever bring against an auditor. And the second issue is whether that is true or not, however that issue is determined, when is the appropriate start date for limitation for claims. I see my lord nodding. I hope that addresses at least some of what he was asking me.
Yes, yes.
Well, I'm
You're right there.
And I'll come to how that's broken down in a minute. Can I just take your lordships very quickly to give an overview of the judgment? I'm going to do this at a sort of bird's eye view. What you can see from the judgment is that there is quite a long introduction, first dealing with the Lebanese legal provisions. That starts at paragraph 14, page 6 of the judgment. And they're set out there a version of the English translations of the Lebanese laws. That goes on for half a dozen pages. Then from page 13, paragraph 15, there's a summary of the parties' cases. And then from paragraph 32, there is a section dealing with the expert witnesses. First, Professor Slim, that's at paragraph 37, and what they say about the issues. And then at paragraph 66, Maitre Matar, his views on the topics, starting at paragraph 66 and going through to paragraph 83. After paragraph 83, there is a long section which is headed in italics, the principal views of scholars, judicial decisions and legal provisions put by the defendants to Professor Slim in cross-examination.
Yes.
And that goes on from paragraph 83 through to 117. There's then the mirror image of that, the principal views of the scholars and judicial decisions relied upon by the defendants in the cross-examination and re-examination of Maitre Matar. That starts after paragraph 117 and goes through to paragraph 125. It is then only at paragraph 126 that you get the judge applying his judicial mind to the questions before him, discussing the arguments and making his decisions. So everything up to paragraph 126 is a description of what the party's case is. We take no real issue with anything that's said up to that point. The judge summarizes various of the arguments. We don't say everything comprehensively, but we don't say there's an obligation that he do so. So paragraph 126 is where the meat starts, and you have from paragraph 126 to 151 the judge's decision and discussion about issue 1. That is the recoverability reflective loss point. So that is 26 paragraphs, quite detailed analysis of the recoverability point. And we say, and we will say tomorrow, that there's nothing wrong with that. That's all carefully set out. All the coherent reasoning by the experts is addressed, and the judge comes to what we say is an unimpeachable decision on that topic after 26 paragraphs of consideration. Issue 2 starts at paragraph 152. You have the first 3 paragraphs dealing with the question of governing law. That isn't under appeal. That's 152 to 154. You then have 2 paragraphs, 155 and 156, that set out the entirety of the judge's discussion and decision on what I will call the scope of Article 178. And for reasons I'll come to, we say that it's only really 156 that has any reasoning at all. That doesn't bode well, but isn't necessarily fatal. But we do say it's all in one paragraph. The judge's discussion and decision on Article 178 is all contained in one paragraph, 156. There is then a slightly longer section starting at 157 and going through to 169, which deals with the other issue about when the time starts to run for limitation, the start date issue. And although that is longer, again, we say actually the entirety of the judge's decision and his analysis is actually contained in 2 paragraphs, 167 and 168. Admissibility is then dealt with from paragraphs 170 to 181. And so there is then 12 paragraphs that deal with that issue, albeit that isn't under an appeal before the conclusions. That's the layout of the judgment. And we say immediately, you might be somewhat sceptical that the issues which are as complex as they are took so little ink in the judgment for the judge to come to his decisions. And we say there are certainly in relation to Article 178 inadequate reasons for the judge's findings at all. You cannot see how he has come to his conclusion. Can I take a small detour here? One of the topics, one of the reasons that permission to appeal was granted first by Justice Field and then by your lordships on this case was because the topic of how to grapple with appeals on matters of foreign law in this court has not, I think, been addressed previously. That there is, following the decision reported as Fidel and Felicia, a approach agreed in this court by the then Chief Justice that he termed the international approach as to how one should approach approach foreign law, but that appeal does not conclusively decide how the Court of Appeal ought to approach appeals on foreign law. And everything we're going to be dealing with today and tomorrow is couched in Lebanese law. Can I take you to Fidel and Felicia to show you the point I'm making here? It's in volume 7. I have it at page 444. And if we type in 02 dash, this is not going to work, I predict. No.
Dash 4444.
Let me see if I can find the case lines page number. It's going to be.
I'm sorry to interrupt, but if the Chief Justice can view it in PDF, we can just use the black numbers. So if you click on the button and view it in PDF, we can all use the same numbers rather than trying to use these red numbers. That's what the parties had agreed.
Where is the PDF? I don't understand what you're saying. I got on my screen only, find page. On my pages, there are 02444 and 02444. There is no other numbers. I don't understand what you meant. Oh, I see.
Yeah,
0482.
there should be a button.
Okay.
Yeah.
But how do you get that? How you get to there? Can I can't punch to 0428. It won't go there.
When you open case lines, there should be a button. We can send you a screenshot that says original PDF, and you can then just view the black numbers. Yeah.
Original PDF. Where does it say? Oh, find view. View. Is it under view? You get what Ms. Day is saying, Shamlan? I know the numbers you are saying there at the bottom.
No, I
There is a
haven't
black.
tried this before.
It's black in number. It's a black
Yeah,
printed
it's
number.
the black numbering, and if you're in PDF format, you can find the page by pressing Control and Find, and then you just type in the number.
Control the sign. Never mind. I think you just go ahead, and I'll try to figure this out. In the meantime, we'll just use your way of Mr. Thompson. We'll just use your way of identifying.
I'll try. I think if you type into your box 02-4580, we might get the page Miss Day and I call 4444. That if it comes up, you should have a judgment.
Fidel against Felicia. I got it.
That's the one, exactly. And I'm going to be looking at paragraphs 43 to 45 first.
43. Okay.
This is a decision of the Court of Appeal. This is the then Chief Justice Michael Huang's decision on the way in which one ought to approach foreign law in the DIFC courts. And he says at paragraph 43 that the starting point is the rules of evidence to be applied. And he makes the point first at paragraph 44 that Article 50 of the DIFC courts law says that the rules that can be applied in proceedings are rules that are prescribed in DIFC law. Well, there is nothing on foreign law in the DIFC law. The rules as applied in the courts of England and Wales or the DIFC courts considers appropriate to be applied in the circumstances. And what the Chief Justice did in this case then was to say that the appropriate law to apply, the appropriate rule of evidence to apply in cases where foreign law is applied, it is, as he put it, that following the international approach. If you go over the page, you can see at paragraphs 48 to 49 that in this case, which is a case of non-DIFC UAE law, that the judge found that the relevant DIFC courts possess the discretion to apply such rules of evidence as it considers appropriate in the circumstances of any particular case. That's Article 50, including the rules as prescribed in DIFC law and English law. The question is then what rules of evidence would be considered appropriate to apply to questions of non-DIFC UAE law before the DIFC courts, whether it be the English approach, the Talim approach, or some other approach altogether. In my judgment, neither the English approach nor the Talim approach is appropriate for the DIFC courts. Rather, the DIFC courts should adopt the approach of accepting all submissions on non-DIFC UAE law as part of legal submissions, as is usually done in international arbitration, with regard to issues of any national law. And I elaborate on this proposition. And you can see then that what the judge then does is consider the English approach, which he calls the fact doctrine, where foreign law is treated as fact, has to be pleaded and proved by the submission of expert evidence. And he points out that even in England, there are some quirks of this approach insofar as foreign law is dealt with slightly differently from other types of fact. We'll come back to that point if I may. He then deals at paragraph 60 with the Talim approach, only to reject it. I'll come back to that as well, and concludes at paragraph 66 that the international approach is the appropriate way. And it's paragraph 66 and 67 that deal with this. It says 66, as stated by the Deputy Chief Justice Coleman and Talim, the DIFC courts are no ordinary courts. They are common law courts administering justice with a circumscribed jurisdiction covering civil and commercial matters only within a wider jurisdiction exercised by the non-DIFC Dubai courts in the UAE. The non-DIFC Dubai courts administer local law that's derived from the civil law system, with different principles applying both in relation to substantive civil law and in relation to the deducing of evidence. Some, but not all, of DIFC judges are trained in non-DIFC UAE law. The result is that where questions of non-DIFC UAE law arise before the DIFC courts, the judge hearing the matter may or may not be qualified in non-DIFC UAE law. And where such questions arise before the DIFC courts of appeal, the judge hearing the appeal may be comprised of only some judges that are qualified in non-DIFC UAE law. Such a situation is analogous to the situation in international arbitration and international commercial courts, where the arbitral tribunal or court may be made up of arbitrators or judges with very different qualifications, with some who may not be qualified in the applicable or relevant law for the issue at hand. In such a scenario, the fact doctrine, the English approach, is an inapplicable legal fiction, and international arbitral tribunals and international commercial courts instead treat all law as law, with counsel making legal submissions on disputed areas of the applicable or relevant law, appending expert opinions if necessary, and in the case of international commercial courts, the court being allowed to take judicial notice of the foreign law in question. And that is the approach that commends itself to the Court of Appeal in that case. And the judge goes on to say in paragraph 71 and 72 that this approach, the international approach, should be applied not only to non-DIFC UAE law, but also in 72 all questions of non-DIFC law. So since that case, it has been the law in the DIFC that all foreign law is treated under an international approach. Now that is set out in detail at paragraph 72, but it's important to point out that at 73 over the page, the Chief Justice says, accordingly, given the judgment that this court has to adopt such rules of evidence as it sees fit, including the rules on the receipt of opinions of legal experts, I take the view that in all cases where legal experts are offering expert reports on issues of any law other than the DIFC law, i.e. not merely non-DIFC UAE law, the practice I've described above should be the starting point for deciding on the procedure to be adopted for the presentation of expert legal reports. The presumptive rule should be that legal experts are to write briefs with their analysis of the relevant legal principles of the applicable or relevant law, and to make further submissions applying the legal principles to the facts as alleged by the respective parties, or to argue for a particular decision to be delivered by the court. I should make clear that this is only a presumptive rule, and the trial judge should always have the discretion to proceed in the manner in which he considers most beneficial for his education in a system with law with which he is not confidently familiar, even if this results in adopting either of the other approaches described above, i.e. the English or the Talim approach, or possibly even some other approach. For example, the relevant legal expert may not be qualified to act as counsel in the case because he does not meet the requirements for registration as a practitioner with rights of audience under Part 2 of the Register of Practitioners, and so on. So the judge says that should be the presumptive rule, but it is a starting point from which the judge can divert. Now, there's no doubt on the facts of this case that actually the judge did divert, in the sense that the rule, the directions which were set down and followed, admitted of expert evidence provided by Professor Slim and Maitre Matar that was received by Justice Field and decided upon on the basis of their cross-examination in front of him. So what my learned friend will say is, well, obviously what happened below was that the judges decided to take the English approach. I accept that that is the case. The question is, what should the Court of Appeal do? Before we go on to my submissions of what the Court of Appeal should do, can I take you to the next judgment in that bundle, which is Pro Viti? And I should have pointed out that in the one I just took you to, Justice Field was a member of the Court of Appeal, as he was in the next case, which is Pro Viti. Now that is the case that starts at, in the case lines reference 4590, or in the PDF 4454. The Court of Appeal decision of 2016. And in this case, Justice Field gives the decision of the Court of Appeal. It also has the Chief Justice, Michael Huang, as a member of the panel. If you go forward to paragraph 54, which is at page 45, I think the case lines to think about it, 4599. I want you to look at paragraph 54. Now, this was, just to be clear, this was an application to set aside service out of the jurisdiction. It was actually an application considering forum non-convenience. And in paragraph 54, the Justice Field is considering a submission about what the weight the judge gave to the fact that the claim was likely to be governed by the law of the Kingdom of Saudi Arabia. And Justice Field says this: I also reject the submission that the judge gave inadequate weight to the fact that the law applicable to the respondent's claim was the law of the KSA. The weight to be given to this factor was a matter for the judge, and in my opinion, his consideration of this aspect of the case does not fall outside the permissible ambit inherent in the evaluative exercise he was undertaking. True, it is that the law of the KSA is derived from the Quran and the Sunnah and knows of no doctrine of precedent, but amongst the judges of the DIFC court, there are 3 Arabic-speaking justices, and the international approach to deciding issues of foreign law adopted by this court in, that is the case now known as Fidel, will assist in the determination of such issues under the law of the KSA as may arise following the service by the appellant of a defence. So Justice Field and the Court of Appeal there are clearly saying, even if it is the law of the Kingdom of Saudi Arabia, which has a common language, and other potentially similar aspects to the civil law in the non-DIFC UAE law, that in itself is something which the judge below could have given weight to. And that has been read subsequently as being a determination by the Court of Appeal that any foreign law might be dealt with in a way the judge thinks fit, appropriately in the courts of the DIFC, and isn't necessarily going to be a very weighty factor to take the matter outside of the DIFC as an appropriate court of jurisdiction for the resolution of disputes. Now, so then I come back to the question of what this court ought to do, the approach this court ought to take. Now, like Saudi law, Lebanese law is written in Arabic. It is derived from French, but it is written in its authoritative version in Arabic. And I deduce that this tribunal, and indeed most Court of Appeal tribunals in the DIFC, will have at least one Arabic speaker, native Arabic speaker, who will be able to read the Arabic, just as in Mr. Justice Field's judgment that I just read you out, the judge of the DIFC will be able to do in a trial governed by Saudi law. Now, if you now go back to, I want to go back to the Fidel case that I took you to, just to show you some specific concerns which were raised in that case about what was called the Talim approach, because they're instructive as to the position which I say you ought to take here. So I want to go back to paragraph 64A, which is at page 4447 for those of us on the PDF, or 02-4583 on case lines. Now, paragraph 64, the Chief Justice is dealing with the disadvantages of the Talim approach, and one difficulty he is recording is conduct of appeals. He says, the second difficulty is dealing with the conduct of appeals. This is illustrated by the following scenario. In one scenario, suppose that the trial judge were not qualified in non-DIFC UAE law, and expert evidence was then required to prove the content of the non-DIFC UAE law in question. An appeal is then brought, and the DIFC Court of Appeal, made up of judges both qualified and unqualified in the non-DIFC UAE law, would have to deal with the issue of the correctness of the trial judge's findings on the content and interpretation of the non-DIFC UAE law. Should the non-DIFC UAE law qualified judges resolve the issue by reference to the expert evidence, notwithstanding they are fully qualified in it? Further, since the English approach expects the appellate court to apply its own legal skill and experience in resolving questions of foreign law, should the DIFC judges who are qualified in non-DIFC UAE law apply their own expertise to the issue, with the DIFC judges who are not so qualified deferring to their opinions, notwithstanding they may have substantial judicial experience in non-DIFC UAE law. Now, he cites that scenario, along with two others, to highlight the ridiculousness of that sort of situation. The situation where you might have a judge who is qualified in the law governing the appeal, unable to use their expertise, notwithstanding that they were trained and qualified in it, and other judges who had experience in such law also having their hands tied, so they had to deal with it on the basis of a pure question of fact, as would be the case under English law. And this is one of the reasons why Chief Justice Huang decides against the Talim approach. Go forward another page to paragraph 70. This is at 024585 or page 4449. In paragraph 70, Chief Justice Huang, who was obviously from Singapore, refers to the Singapore International Commercial Court and points out that in that court there is an option of adopting the international approach under the rules of court. But it's the final sentence I wanted to take you to, starting 4 lines from the end. In an appeal from an SICC judgment or order to the Singapore Court of Appeal, the Singapore Court of Appeal may also determine any question of foreign law on the basis of submissions, either in its own motion or in a party's application, or where the question of foreign law has already been ordered by the SICC to be determined on the basis of submissions. So that is the way it can be dealt with in Singapore. The problems which are identified in the scenario set out by the Chief Justice in 64A are problems, in my submission, that are equally acute, or at least still exist, in circumstances where one of the members of the Court of Appeal is able to read the fundamental laws that are under appeal in their native language, particularly when there are questions of construction which arise. So we say the fact that the English approach was taken by an English judge at first instance does not mean that the English approach need be taken on appeal. We say what the Court of Appeal ought to do, and we invite the Court of Appeal to set down some guidelines on this point, is hear submissions today on the Lebanese law and deal with the judge's conclusions on the law as if they are conclusions on law. That is to say, you oughtn't to deal, as you would in England, with this appeal as if it were a question of an appeal on facts. You ought to deal with it as if it's a question of an appeal on law. And that is because, as with Saudi law, Lebanese law is written in Arabic, and the judges on the Court of Appeal will likely always have at least one member who is able to interpret those rules with the benefit of their similar, even if not identical, legal training. That is in line, we say, with the flexibility that Chief Justice Huang was trying to introduce, did effectively introduce into the international courts of the DIFC, and is also consonant with the international approach that this court wishes to take to matters of international dispute. It aligns more closely with the international arbitration schema, as Chief Justice Huang now said. Now, furthermore, I don't invite you to decide this now, but at the end of this appeal, when you stand back and consider the submissions you have heard, in my submission, you will think to yourselves, well, those all sounded rather like submissions about an error of law. Those submissions that Ms. Day and I will be making, I am confident, will not be ones where we are saying, well, the judge, against the weight of the evidence, decided something wrong, like you might hear on an appeal on an issue of fact. They will more sound like appeals of law. They will more sound like submissions about appeals of law. This question the judge decided was wrong. If you look at the law, that can't possibly be right. And we'll be making submissions in essence which go to the correctness of the Lebanese law conclusions drawn by Justice Field. I will say, just to be clear, in my submission, this isn't materially different on the facts of this case, or won't be significantly different from the way in which it might obtain in England anyway. And we will see from a couple of cases I'm going to take you to, if I can find the pages, that even in England, when there are appeals on matters of foreign law, they are treated in quite a special way, different from how they might be treated on appeals of fact. Can I take you to just, I'm going to take you very quickly to 3 judgments to prove that point, although obviously I'll have to struggle with the pages again. In the PDF, I wanted to take you to the case of Grupo Torres and Sheikh Fahad Mohammed Al Sabah, which is 3872 in the PDF, and let's have a rough guess where that might be. Yeah, I'm going to try. It's a bit of, yeah, here we go. So this is it's 023992. 02-3992. So this is an English case of the Court of Appeal in 1995. I only want to look at one paragraph of this, and it's paragraph 43. So you go forward to page 3889 on the PDF. On the case lines, it's 02-4009. And this is the judgment of Lord Justice Stuart Smith. At 43, he says, questions of foreign law are questions of fact, which must be proved to the satisfaction of the judge. If the evidence of the expert witnesses conflict, it is the judge's duty to resolve these differences in the same way as he must in the case of other conflicting evidence of fact. The judge is free to scrutinise the witness and what he says as on any other issue of fact, and can use his common sense to reject the evidence of an expert witness if what he says is patently absurd or inconsistent with the rest of his evidence. However, where the evidence of an expert witness on foreign law is not contradicted, the judge should be reluctant to reject it. The Court of Appeal should in appropriate cases be more ready to question the judge's conclusion on an issue of foreign law than it is on other questions of fact. But it should be extremely reluctant to substitute its own views where questions of credibility are concerned, since the judge has the benefit of seeing and hearing the witnesses. Now, just to be clear, in the case before your lordships, as I would say in 99% of cases on appeals of foreign law, there was no question about credibility of the 2 expert witnesses. They were both, the judge found, patently credible witnesses qualified to say what they were saying. I will say Professor Slim was more authoritative, but I certainly don't suggest that there was anything incredible or dubious about what Maitre Matar said. The next authority in time I want to take you to is the Macmillan and Bishopsgate case, number 4 of that series of long-running litigation, which is at tab 84 in the PDF. It's at page 4269. Case lines, it is 4397, 024397. Now this, another judgment of the Court of Appeal a little bit later in the 90s. Can I take you just to one critical paragraph, maybe 2 paragraphs, 12 and 13, which starts at 4273 of the PDF or 024401 on case lines. At paragraph 12, this is a judgment of the court delivered by Lord Justice Evans. So we come to consider what the court's approach should be when the trial judge has heard expert evidence as to foreign law and made findings which are challenged on appeal. What difference does it make that these are findings of fact, but of a peculiar kind because they're concerned with issues of foreign law? In our judgment, the answer varies according to the nature of the issue which arises in a particular case and the kind of decision which the trial judge and now the Court of Appeal is called upon to make. Sometimes the foreign law, apart from being in a foreign language, may involve principles and concepts which are unfamiliar to an English lawyer. The English judge's training and experience in English law, therefore, can only make a limited contribution to his decision on the issue of foreign law. But the foreign law may be written in the English language and its concepts may not be so different from English law. Then the English judge's knowledge of the common law and the rules of statutory construction cannot be left out of account. He's entitled and indeed bound to bring that part of his qualifications to bear on the issue which he has to decide, notwithstanding it's an issue of foreign law. There is legal input from him in addition to the judicial task of assessing the weight of the evidence given. The same applies in our judgment in the Court of Appeal, when and to the extent that the issue calls for the exercise of legal judgment by reference to principles and legal concepts which are familiar to an English lawyer, then the court is as well placed as the trial judge to form its own independent view. Now, that is underscoring the flexibility of the English approach, or the width of the English approach when there are appeals of foreign law, but also in my submission underscores why it is appropriate for an international court like the DIFC to allow the legal input of judges qualified in different systems to be brought to bear on the issues under appeal, even if those skills and training and qualifications differ from those which the judge below had himself. The final case I want to look to on this point is a much more recent one decided this year, the case of Byers, which is at page 4366 of the PDF. And so that is O24502 in case lines. And again, I only need to look at one paragraph of this, which is quite a long way down at page 4398. Which is in case lines 024534. And this is a judgment of the Court of Appeal this year, and it says foreign law is a question of fact which the trial judge is required to determine on the basis of the evidence deployed by the parties. The task for the judge is to determine what the highest available court in the foreign jurisdiction would decide if the point had come before it. The phage approach remains the starting point in any appeal from such a determination of foreign law. However, it may be qualified because the question of foreign law has been described as a question of fact of a peculiar kind. That's Parcasho, you have that in the bundle. It dates back to the 60s. Macmillan, then the passage I have read to you is set out and supported again by the Court of Appeal this year. So there's no doubt that that is still the approach in the Court of Appeal in England. In this case, as I say, there's no question of witness credibility. And on either approach, whether you take the English approach or the international approach as a Court of Appeal, we say you are in as good a position as the judge of first instance to determine the questions of Lebanese law, arguably a better position than the judge in first instance.
Mr. Thompson, where is it that you think or you're submitting that Mr. Justice Richard Fields went wrong? Where is it? I know you're saying that we are in the same capacity. We have the same. We can be sitting as a judge of first instance decide. We don't deny that fact. We can because the on point of law, foreign law, the fact is not the fact as you are judging the credibility or witness and things like that. This is a matter of expertise. So we don't deny. I think we accept that. But why do you say Richard Field was wrong in his conclusion?
Well, you're right to push me. I haven't got to that point. I'm nearly an hour in, and I haven't addressed.
Yeah, that's right. You're running out of time. This is why you're going a lot of the basic part of it, which I think we don't disagree with you. I don't think Ms. Day disagrees with you.
I'll move on from that point. It wasn't clear to me that your lordships would be with me on this point. It is a novel point. And I won't make further submissions on it if your lordships are with me.
Let me before I decide that, I would like to ask Mr. Justice French and Justice Shamlan what they think. Are they with me, or are they, on the bench we can whisper to each other? Here we can't do that. So Justice French, can Mr. Thompson go on to the? He can't hear us, can he? Justice.
I think he can hear us. Maybe we can't hear him.
All right. Can you hear me now?
Yes.
Okay. I don't think we need to commit definitively to a position on the international versus the English approach, although I suspect the difference may be more apparent than real. Can I just say that from my own point of view, it seems that the English approach may well be located in the necessity to fit with the notion of experts giving evidence and being examined and cross-examined, and therefore you characterise it as a question of fact. We've moved on, and certainly in Australia, we've moved to a position where some expert testimony is actually treated as submission, and we actually brought that into some of our rules. And so it's really a matter of taxonomy, and I think the Parcasho case sort of throws up the sort of fault lines in the taxonomy. But I wouldn't want us to take a definitive position one way or the other until we've heard all the argument. I also, like the Chief Justice, I want to know precisely how it is said that whatever approach Justice Field took led to error in his conclusion, and whether it would have made a difference. But I just don't think we should be saying making a definitive statement about the approach to dealing with foreign law at this stage in the argument.
That's extremely helpful. I hope we haven't lost the Chief Justice now. I can't see.
I'm here.
Good. Good. Just your camera's off. That's very helpful, Justice French. Thank you. I will move on. Needless to say, I am going to address what we say Justice Field did wrong. But I did want to ensure you had my submissions on this point. I'm certainly not inviting you to make the decision before we proceed. And I certainly agree, for what it's worth, that in this case, the difference might be marginal. I don't think it's nil, but I think the difference of approach might be marginal, and it certainly wouldn't, I think, alter the way I would make my submissions.
Incidentally, Mr. Thompson, I'm sorry to interrupt you. The question I was trying to put to you earlier on, when I retreated into silence, was to what extent can we, in all this sort of surrounding white noise, I'm not trying to put down your submissions when I say that, but in terms of the complexity, if one might, that we're really getting down to are asking interpretive questions about when a claim is due. That's the first interpretive question. And secondly, what's the scope of the concept of supervisory default? They're really the interpretive issues, aren't they, on the limitations point?
I mean, at a high level, I would tend to agree. I think there are different ways of framing those questions, and I'm not sure I would agree with your lordship with respect that it's entirely questions of construction. Certainly not simple questions of construction. No,
I appreciate that. I mean, construction is contextual and purposive, and obviously we have questions about what is the effect of Lebanese rules of construction, or the contextual principles within which we approach these things. But ultimately, I'm just trying to get right down to the wire on the questions. The questions we're asking is when did the claim become due? Is it accrual with loss and damage, or is it earlier on when the breach occurs? Contract versus tort, for example. And secondly, what's the scope of the range of defaults? Is everything that an auditor does supervisory or not? That I just wanted to understand that they were the sort of bottom line issues we were getting down to in this debate.
They are the bottom line issues. They're the two topics that I ought to be spending the bulk of my time on dealing with today. Obviously, my introduction has trespassed onto these other areas of the Court of Appeal's approach. But let me move on to those. But I don't demur from those as the broad topics, though I might frame them in slightly different language. But I don't demur from them as being the two main areas of appeal. In fact, in that regard, sorry, Anna, could I just emphasise the point that you did make? But it is, I think, important to consider the approach which must be taken in interpreting Lebanese law. And on that, we say the judge did err, and in making that error, he then came to the wrong answers on the two questions that your lordship has framed. So it is an error of process, if you like, which then leads to an error in result.
Okay, thank you.
Fine. Well, in that case, let me move on. Let's go to the heart of the matter. I want to look firstly at the relative Lebanese law and the structure of the law, so we can see what the judge was here considering with. Considering this is usefully set out in the judgment itself, so we can go back to the judgment, and unless your lordships tell me otherwise, I'm just going to use the paragraph numbers and the page numbers, the internal page numbers of the judgment. At paragraph 14, the judge set out the provisions. Now, there are various different translations of these in the bundle, and some of them are materially different, but I think we can take them at the moment from the judgment. And the first one I want to take you to is Article 122 of the Code of Obligations. Now, that is at page 10 of the judgment. That's the 10 of 69 at the bottom. And to be clear, this is in the Lebanese the Lebanese Code of Obligations, and it says at 122, any fact due to man's action which causes unjust prejudice to another man compels its author to offer reparation, at least if he's gifted with understanding. And in the second article, immediately below, Article 123, it said a person is liable for the damage caused by his negligence or by his improvements. That should clearly be imprudence. It's a typo. Imprudence, as well as may what results from a positive act. So effectively, this is the classic statement, the French statement of liability. You need fault and you need damage, and then you need some causal connection. And the experts below were agreed on this. It's common to any civil system that that basis of liability in delict or quasi-delict is predicated on a man's action or omission which has caused prejudice to another and loss. Now, Professor Slim goes into some detail, which I don't need to, I think, but the basis is that everyone's under a general duty not to cause damage to another. It's obviously translated in common law to the concept of tort, and particularly to the torts of negligence in Article 123. But really, this is the underpinning of the claims in delict in Lebanese law. Now, as for limitation, you need to look at the article over the page, two articles over the page, 348 and 349. So on page 11 of the judgment, Article 348 reads, time limitation is computed only as from the day when the claim has become due. And Article 349 says, in principle, no action should be brought after the expiration of 10 years. Now, that then are the starting points for limitation periods, and the general rule is 10 years. This is the most general principle about it. If you go to the Lebanese Code of Commerce, you can see another article dealing with time. The preceding page, or 2 pages before, page 9 of 69 of the judgment, Article 262 says, in trading matters, action is lost by time limitation after the lapse of 10 years, whenever no shorter term has been set. And the experts again were agreed that that relates to all commercial claims, not trading in a limited sense, but all commercial matters. So it's the same limitation period. So nothing really turns then on that. I then want to look a little bit closer at the Lebanese Code of Commerce, and you have it in bundle 7. It starts in the PDF at page 3533. That is in case lines 02-3439. No, that's wrong.
4534, 4534, I think.
I
Your
would,
PDF is 4398.
no, it's three. Sorry. The
PDF what?
is 3533.
3533. Okay. 38. It is.
Does I want to make sure you have that before I go too much.
It refused to go. What is your other thing? Your
The case lines reference.
mm.
That's a good question.
02. Can you help Miss Day?
Sorry, we're working off these PDF numbers because that's what had
Okay.
been agreed would be the numbering to be used today. So apologies. I can see if
No,
someone
no,
of
but
mine.
It's
no,
not, it's not
we-
Mr. Tom's fault. It's me.
No, but-
I can. I've
I don't
got
know,
this PDF, but I cannot access PDF.
No. Just one second, CJ. I don't know when Ms. saying it has been agreed by the registry. The judges never said we're going to go with working with the PDF. We're working always with the way how it's work.
Case line.
Usually we're using
Case line.
the reference,
Case line.
the case line.
Understood.
So I don't know.
Yeah, hopefully Mr. Thompson's solicitors could maybe email the page
Never mind.
or mine will have a look.
Let's not worry about that. Let's go on to what is it now? Is
Let
it
me-
02 what? 02 what? Is it? What page is that?
02-3533 CJ.
3533. Okay.
Yeah.
I got it. Yeah, okay. There is a printed old typewritten page.
Yes. I wonder whether that's the same page I'm looking at.
The lessee's obligation, it says
What
there.
do you have a PDF printed black page number?
PDF is 3421. 3421.
Yeah.
At the bottom of the page is 3421.
Right. So I need about another 120 pages further in than that. So three.
So what
I
is
think
it?
it's going to be 02-3645, something like that. And if can I perhaps
Code of
say-
Commerce, is that it? Code of Commerce? Are you
Yes.
referring to the Code of Commerce, Mr. Thompson?
Yes, I am.
Yeah, okay. I got
I'm
here
gonna find a better way of doing it.
3534 on the PDF 3534.
Okay, I have found a solution to this problem, I hope. So hopefully this won't delay us too much longer. So yes, I'm starting at page 023645. 023645.
Okay.
Now that's the
Okay.
code of commerce. In the PDF,
Yeah.
it's 3533.
Yes, that's right.
Right. Now, if you go through to the table of contents, which starts at 3539, case lines 023651. I'll give both references, but the case lines is 023651. Now, what you see is this code broken into books, and it's book 1 deals with trade, merchants and stock in trade. Book 2 deals with commercial companies. It's book 2 we're here concerned with, and book 2 is then broken down into title 1, general provisions, title 2, partnership companies, title 3, joint stock companies. Joint stock companies is then the title we're concerned with, and you see joint stock companies has chapters. Chapter 1, formation over the page. Chapter 2, securities, dealing with shares and debentures. Chapter 3, operation of joint companies. And it's this particular chapter we're going to be focusing on. So the operation of joint stock companies then deals with directors first and supervisory commissioners next. Now, this is important. The operation of joint stock companies there is broken into 3 different sections: directors, supervisory commissioners, which everyone accepts is a homonym for, or a word meaning auditors, and then shareholders general meetings. So I want to look at those three sections distinctly. The first section then on directors starts at page 3567 of the PDF. Of case lines is 02-3679, 02-3679. And it's right at the bottom of the page, Article 144, which deals with directors. There then follow several pages of articles dealing with directors, and they deal with things like the remuneration of directors, the number of directors that need to be on a board, how to elect them, how to remove them, restrictions, chairmans, board meetings, so on and so forth. That goes through all the way through to Article 171. Only the final half a dozen of those are going to be a focus today, because starting Article 166 are various articles dealing with the responsibilities and duties of directors and how claims might be brought against them. So Article 166 on the PDF at 3572, on case lines at 02-3684, it deals with fraud and infringements to the law and articles. Directors are responsible, it says, even towards third parties, for all fraudulent acts and all infringements to the law and articles. Proceedings open to the injured parties are individual, so individual claims, we'll come to that tomorrow. They may not be checked, by which it's meant stopped, even in relation to shareholders by a vote of the general meeting granting final discharge to the directors. Section 167 has two paragraphs. The first one is more important than the second for present purposes. The first one reads, the directors are on the other hand responsible to shareholders for their mismanagement. So a distinction is made between mismanagement in this section and fraud and infringements to the law and articles in the preceding section. The longer second paragraph of 167 deals only with insolvency, and I don't think we'll need to drill into it today. There then follows Articles 168, which we will have to look at tomorrow, but I don't think today, and 169, which is important and says final discharge, if it is to be used as a defence, must always be preceded by a statement of the company's account and the commissioner's report. It only covers facts of management with which the general meeting may have been acquainted. And what that deals with, I think I could say uncontroversially, is the fact that accounts and auditors' reports will or ought to be put before a general meeting of a company, and that might give a discharge to the liability of directors. And in particular, what that does is it starts time running, as we will see, for claims against directors. That you can see over the page on Article 171, because Article 171, which is critically important, reads proceedings for liability are limited to 5 years, dating from the meeting during which the directors were required to account for their management. So Article 171 harks back to 169, talking about the meeting at which directors have to account for their management. Article 169, as you recall, deals with management facts which are covered in reports to general meetings, and Article 167 deals with management. None of those three articles touch upon fraud or infringements to the law and articles. Just to point that out, those all three articles, 167, 169 and 171, seem to be dealing with mismanagement. That was a live issue below, which we'll come back to. That's all to do with directors. The next section 2 is headed supervisory commissioners. This is just above Article 172. And here you have 7 articles dealing with supervisory commissioners, or auditors, as they're now called in English. And what you have is the first 2 articles dealing with the appointment of these commissioners. The next 2 articles, sorry, the first 3 articles dealing with appointment and power and control, 172, 173, 174. Then 175 and 6 dealing with the duties. 175, commissioners report to the general meeting on the situation of the company, the balance sheet and the accounts table before them by the directors, and the proposed dividend distribution. Failure to produce this report will nullify the deliberation of the general meeting approving the account. So that's the obligation to put the report to the general meeting. And 176, commissioners are required to convene a general meeting whenever the directors omit so doing in cases specified by the law or the articles. Likewise, they are empowered to convene the meeting in all cases they deem if needful. They're even bound to do it when they are required by a group of shareholders representing 1/5 of the company's capital. So another duty which might arise in certain situations. And then 177 is a restriction on taking an interest. And 178, critically important for this case, is about responsibility. They say they commit their responsibilities either individually or jointly, even towards third parties, whenever they commit a supervision offence subject to the 5-year time limit. Those are the only articles you find in the Lebanese Code of Commerce dealing with supervisory commissioners. Now, as a matter of general point, I don't think this was really in dispute, auditors are really sui generis then. They are not agents of a company. They can't bind the company like a board of a company can, but they are a sort of organ of the company with certain obligations to it. It's certainly the case now, even if it wasn't when this code was first introduced, that they can owe duties to persons other than the company, and importantly, they can owe duties now to the central bank, because although it isn't set out in this code, which dates from the 40s, there are now, as you've seen, obligations imposed on auditors, external auditors, to report matters relating specifically to money laundering and terrorist financing up to the central bank. Article 178, before we move on from the article itself, I should point out, has no restriction on who might sue an auditor. It only talks about responsibility. It doesn't talk about rights and who might have those rights to bring those claims. Now, how to interpret these provisions, the critical question in our case, was a matter of some debate below. Let me set out broadly the position which Professor Slim advanced. He said, and I should emphasize, not much of this, I think, was really in dispute, that there are codes and statutes which have equal status that are supplemented by decrees and circulars. Everything I have read you so far about the Lebanese law is in a code. But the interpretation of these codes is itself the subject of codification. Obviously, in a civil law system, they don't have the principle of stare decisis. However, it's certainly clear that judges are entitled to take into account what other judges have said, even if they're only illustrations of how the law is said to work. Equally, Lebanese judges are entitled to have recourse to the work of scholars, much as common lawyers have done certainly in recent times, in order to assist in the analysis of the interpretation of the law. But the codes themselves, it must be said, prevail. There are, however, specific rules of interpretation that are critically important, and two of the most important ones are set out in this code. They're right at the beginning in the general section. So if you go back in the PDF to page 3543, in case lines it's 02-3655, you can see Articles 2 and 3 at the beginning of this code dealing with interpretation. Article 2 says, unless otherwise specified in the present code, the Code of Commerce, common law provisions, which means general law provisions in other more general codes, shall apply in commercial matters, only insofar as they are reconcilable with the principles proper to the commercial law. Now, pausing there, the first articles I read you, Articles 122 and 123, were from the general code, the Code of Obligations and Contracts. Now, that is a general law provision that applies across the board. It's a rule of delict, and it applies to everything in Lebanon, unlike this code, which is specifically focused on commerce. So what Article 2 says, that unless otherwise specified in the present code, you take into account provisions such as those in the Code of Obligations and Contracts, insofar as they're reconcilable with the principles proper to commercial law. So the background includes Articles 1, 2, 2, 1, 2, 3 from the Code of Obligations and Contracts. That is the background against which the Code of Commerce is to be applied, although the Code of Commerce takes precedence. Article 3 is another codified rule of interpretation. It says, in the absence of any applicable legal provision, the judge can draw upon previous test cases for guidance as much as he may let himself inspired by the strictures of commercial equity and loyalty. So Article 3 covers the situation where there's no provision at all. Article 2 is nothing in this code. Article 3 is nothing at all. So the first thing you do is see, is there provision in this Code of Commerce that deals with the situation? If not, you look at the general provisions in other codes as the background. If there's nothing there either, then you can draw upon previous test cases and try and work out what equity and loyalty would demand. Now, the other provision of interpretations I need to take you to is in the procedural code, a little bit further down in the PDF at 3827, and this is a single article. It's also in the judgment. I perhaps should have said, might be easier. There are two places I'm going to refer you to this. In the judgment at page 12, the Lebanese Code of Civil Procedure, LCCP, has an Article 4, which says the judge shall not, under the penalty of being considered as carrying out a denial of justice, refrain from issuing a judgment on the ground of the vagueness or the inexistence of the text. So the judge can't put his hands up and say, I can't decide this, that there is, the rule doesn't exist or is too vague. And then it says in the next paragraph, in case of vagueness of the provision, the judge shall interpret it in a way that gives it an effect that's consistent with its purpose and ensure harmony between it and other provisions. And in the absence of provision, the judge shall rely on general principles, customs, and fairness. So if there's no provision at all, you can rely on general principles, customs, and fairness. If it's a vague provision, you've got to interpret it in a way that's consistent with its purpose and ensure harmony between it and other provisions. Now,
okay, in your case, in this present case,
yeah,
where does it fall? You're telling a lot of the backgrounds, but I'm still waiting for you to zero in. Where is the 10-year mentioned? Where is the 10-year mentioned? You're going round and round, but I've not seen the 10 years yet.
You're right. I'm building up to it. The tension must be getting indescribable, but I'm absolutely building up to that point, Chief Justice. You are absolutely right that I'm setting the theme for it. What we say, just to break the suspense, is the judge wrongly concluded there was no provision and went off and considered more general provisions and thought and made up a rule that he thought was appropriate.
Right.
When
now you are saying
there
that there's a
is
specific provision. Go straight to the specific provision. Then it makes life easier for everybody, I think.
Okay, I'm sorry, I'm making it difficult. Let's go to Article 178. Now, apologies. So let me pick it up then in the judgment to show you exactly where the judge dealt with this point and what he said about the law first. If you get the right page number for you. In the judgment, if you're working for the judgment on its own internal pages, it's paragraph 53.
53.
Yes.
Okay, 53. 53. Professor Slim observes.
Yes. No, I think, well, sorry, go back. It's paragraph 129. Paragraph 129.
Go back to 129. Okay.
Yeah, 129. So this is on issue 1, but it's important for today. Paragraph 129, the judge said it's common ground that's on its face. Article 178 of the Lebanese Code of Commerce does not limit the entitlement to sue an auditor for supervisory fault to a claim brought by the company, Uch University, or a derivative claim brought by shareholders singularly on behalf the company. As Mr. Matter accepted in cross-examination, the phrase third party in Article 178 includes a shareholder. It's also common ground that to establish the necessary supervisory fault, a shareholder must establish a breach of duty owed to him or her that has caused him or her individual personal loss. And then it's this sentence which is critical for today. I accept Professor Slim's evidence that Article 178 is based on the concept of liability articulated in Articles 12122 and 123 of the Code of Obligations and Contracts. So the judges here correctly accepting that the specific rule about auditors' liability in Article 178 is based upon that general delict article 122 and 123 that I showed you in the Code of Obligations and Contracts. That was his start point, and we don't demur from that. His conclusion, however, was completely wrong. If you look at page 62 of the judgment, paragraph 155 and 156, you see the only thing he says about this topic. And as it's the only thing he says, I'm going to read it out to show you how limited it was. In paragraph 155, the judge rightly says Article 178 prescribes a limitation period of 5 years. It certainly does refer to 5 years. I turn to consider the claimant's case that this article does not apply to those breaches of duty alleged against ETL which stand to be characterised as non-supervisory rather than supervisory. I have summarised in paragraphs 51 to 54 above the contentions that Professor Slim eloquently advances in support of this case, but I'm not persuaded by the reasoning he deploys in his 2 reports or in cross-examination. Pausing there, all that paragraph says is that the judge isn't persuaded by the arguments put forward by Professor Slim. There is no reason why he's not persuaded. You are left to find that in the next paragraph. The next paragraph is the only paragraph in this entire judgment that deals with why the judge was not persuaded. The judge says, I prefer Maitre Mattel's expert evidence that supervisory fault, faute de surveillance, in Article 178 encompasses any fault committed by auditors in the course of carrying out their audit function. As Maitre Matter observes, the word supervision is embedded in the very designation of auditors, commissaire de surveillance, in the LCC, and the scope of the supervisory faults is very wide, as is clear from paragraphs 90 and 91 of Professor Slim's first report. I also find that the distinction between what Professor Slim regards in paragraphs 90 and 91 of his first report as supervisory faults and the examples he gives of non-supervisory faults is unconvincingly artificial. In addition, I think I must give weight to the fact that there is no support for Professor Slim's view in any of the scholarly writings or jurisprudence put before the court, nor am I persuaded by what is submitted in paragraph 79 to 123 of the claimant's closing submissions. There are 3 grounds of the appeal then. The first, which is a standalone ground, is that those are not adequate reasons. And I'll break down what he says to demonstrate that they aren't adequate. The second, and it is a second different ground, is that the judge was wrong as a matter of statutory construction, particularly in relation to the use of the word supervision or surveillance in the designation of auditors and the interpretation of the scope of those supervisory faults. And third, and this is really a sub-ground of the second one, that the judge completely failed to consider a critically important point of context in his construction exercise, and that is the development in auditors' functions and duties since 1942, when the Code of Commerce was first written. And
the inadequacy of the judge, sorry, Mr. Thompson, the inadequacies of the judge's reasons, in a sense, are a distraction in this appeal, aren't they? You just want us to get to different answers in terms of...
I do want to get different answers, but I also say it is inadequate.
But where does that lead you? Where does that lead you? I mean,
well, it is a different route to the same destination, because if you are with me that there are inadequate reasons given, there is no doubt that as the Court of Appeal, you can exercise the evaluative judgment that the judge ought to have conducted yourselves effectively.
Well, let's accept what you say is correct. Let's accept it. How do you ask us to interpret them?
Yes,
I think that's more important.
Yes, well, I'm happy.
You have criticized the judge. The judge didn't give a reason. Now you convince us why we should arrive at the interpretation that you would like us to arrive at.
Don't worry, my lord. I'm certainly going to come to that. I won't forget to do that.
Yeah, but you have already gone how many hours now?
Well, I did anticipate
almost
that
2 hours now.
I did anticipate I might have a little bit of time to deal with the background. But look, I am going to go to that. I will be guided by your lordships on whether I ought to expand upon my inadequate reasons point. But I do say this, it is a ground on which I am going to base my appeal. And so I will invite your lordships to hear me on the point, maybe not first, if you're not with me on the point, certainly. I do say it is separate and distinct from the other grounds, but it is nevertheless, the arguments about what the judge did wrong will also be my arguments as to what he should have done right, and therefore will be common to both. So maybe I'll make those first. Your lordships will tell me whether I need to come back to the point. So,
well, speaking for myself, Mr. Thompson, I would find you've said in your written submissions pretty well everything that can be said about the inadequacy of the reasons. A very succinct point. Really, this appeal is about the correct interpretation of the Lebanese law.
Let me move on then. I hear what you're saying. So the critical question, as your lordship put it to me half an hour ago, is whether or not Article 178 is one that could cover all claims that could ever be made against an auditor, or whether supervisory faults are merely a subset of the particular faults which an auditor might commit. Now, there is no doubt then, as the judge himself accepted, that Article 178 is more specific than Articles 122. There is no doubt that a specific provision in the Code of Commerce dealing with auditors is within its realms something that ought to take precedence over the general provision dealing with liability under the Lebanese law of Deloitte in the Lebanese Code of Obligations and Contracts. That isn't the question. I stress that because that is the error the judge made in thinking that because it is specific, it must be exhaustive. In fact, what Article 178 is a specific but limited provision dealing with one particular type of liability, that is liability for auditors in respect of supervisory faults. The first question then is, what does the word supervisory mean in Article 178 at all? And as we've said in our written submission, the defendant's submissions really come to tantamount to saying that the word supervisory should just be ignored altogether, or maybe read as all faults. Now, there is, just to be clear, no conceptual difficulty with Article 178 being limited to a particular type of fault and all other faults falling into the general law of Deloitte. There's no particular conceptual problem with supervisory faults being carved out of the general law. If that were the case, all that would happen would be that supervisory faults would be limited by the 5-year rule, and other faults, non-supervisory or extra supervisory faults, would fall to be brought under Article 122 with the usual 10-year provision. Now, that is, I hasten to add, exactly the position which obtains with directors. With directors, as I've shown you, Article 171 deals with management faults and sets down a 5-year time period, but fraud and breaches of the law under Article 166 are still under the 10-year rule. And on that point, the judge agreed. That is what Professor Slim said, and the judge agreed that that was indeed the case. He says that at paragraph 167, we'll come back to it. So there is patently no difficulty under Lebanese law, under the judge's other finding, that you can have different limitation periods for different types of claim. And we say, if that's the case for directors, why is it objectionable vis-a-vis commissioners? One of the bases on which the defendants argued and the judge found that this was an exhaustive provision was because of the terminology used in French at certain times in the 19th century to describe auditors. Professor Slim goes into the history of this, but there's no doubt, no dispute, that commissaire de surveillance was a term which was used at a certain point in the 19th century in France to describe auditors. It isn't, interestingly, the term which was used historically, or indeed the term which is used today, but by historical accident, it was the term which was in use at the time when the Code of Commerce was adopted, and that is therefore the terminology which was used in the French version of the Lebanese original codes. But it is a stretch, we say, to infer that the words faute de surveillance, supervisory faults, in Article 178, is then supposed to be read as encompassing any culpable acts or omissions of an auditor, just because that is one of the old-fashioned names which they used to be called. And that is effectively what the judge said. The judge said, because that's what auditors are called, or used to be called, that means that Article 178 must cover everything they do. That is patently a stretch. The fact that it's a stretch can be shown from the fact that today, as everyone accepts, the things they do are not, in any normal sense of the word, surveillance or supervisory. Now, on this point, the judge seemed to accept what Ms. Maitre Matar said, and I will come back to that in a moment, because I will show you that his reasoning on this point was entirely circular. But let me just show you logically why it's wrong. You've already seen that the obligations upon an auditor today include reporting matters of money laundering to a central bank. Now, what Mr. Matter said was, well, yes, but that is simply supervisory. And I infer that what he means by that is that it is something they can only do because they have carried out some surveillance, some supervisory function. Now, that may be true, but does not mean it is supervisory. So the error is really one of language. If I say, as a matter of English or French, I am supervising, or I am surveying the functions of a company, that is effectively a passive role, one that involves me looking at what is going on. That is what supervisory means. Now, there can be elements of supervisory function which go beyond that. There can be elements of reporting. There can be elements of explaining what has to be done. But you cannot elevate or expand the meaning of supervisory to cover everything which auditors now do.
In this particular respect, the reporting to the central bank, this is, you say, a regulatory obligation imposed upon the auditor, which is distinct from the auditor's supervisory role, although it's enlivened because of what the auditor discovers.
That's right. And we say the error in logic is to say that because one is only possible because of the other, it is the other. That is the error. So the identity. Can I use? Let me take an analogy, which I'm conscious one shouldn't push too far. Take a doctor who's a surgeon, and the surgeon diagnoses a particular problem and then conducts surgery to remedy that problem. Now, you might say that the surgeon made a fault in her diagnosis. You might say she misdiagnosed the patient, or you might say she made an error in surgery, but they are two different errors. The fact that the surgery was only done because of the diagnosis does not make them one and the same thing. So here you have the parallel situation. You have surveillance, you have supervision, and then you have actions that need to be done in consequence of that supervision. And it is simply an error of logic to imagine that they are one and the same thing, merely because one is only done on the back of the performance of the other. Now, That being the case, there's one other note of caution which I want to add, which builds upon our Skirton argument. This is all being the logic of the judge, and indeed Maitre Matar, was all done in relation to the French language. In fact, as Professor Slim pointed out in his, I think, his second report, nowadays the Lebanese law is written in Arabic. And there is, in fact, an interesting point here that Professor Slim makes in his second report, which is that the phrase auditor, or the term auditor, is translated into Arabic in various different ways in various different jurisdictions. You won't have looked at this, but can I just take you to this briefly, because it is an interesting illustration of how it might be dangerous to push the point, and also an illustration, if I might say, of why this Court of Appeal might be in at least as good a position as the judge below to consider this question. This is the second report of Professor Slim, which is volume 6, tab 58, page in the PDF 2493, and in the case lines it is 02258. Sorry, 81 2581 02-2581. Now, and in this his second report, Professor Slim points to and transcribes the Arabic term for auditor in paragraph 211. So right at the bottom of the page, limiting myself in this report to the translation in Arabic that was chosen by the Lebanese legislature to refer to auditors, I find it worth to focus on two issues. The first issue is that though company laws in most Arabic countries were inspired from French laws, these laws have not adopted the same translations. While the auditors are referred to in Lebanon in the Arabic version of the LCC as Mufarad Murakaba, I apologize for my Arabic, they're referred to in Egypt, Tunisia, Morocco, and Iraq as Murakab Hisabit, and in Syria as Mufatich Hisabit, in Bahrain, Algeria, and UAE as other terms. So you can see there that although all of those countries have ultimately derived their company law from some version of the Napoleonic Code, they have in fact all adopted different terminology. And in 213, the judge makes the point that the newspapers in modern day actually refer to different term again. They don't use the terminology that's used in the code. So this is not a term that somehow has some specific scientific significance. There are various terms which are used across the Arabic-speaking world in different company codes, all ultimately derived from the Napoleonic and French systems. It was too much of a stretch then for the judge to use the fact that one particular French term for an auditor includes the word surveillance within it, and then to jump to conclude that everything auditors do must be described as supervisory, as in Article 178. That is, that none of that, one has to say, comes from Article 178. There is not one word in Article 178 that describes the fact or delineates how much of the activities of auditors are supposed to be covered by the article. The article simply says they, doesn't even use the word auditors, they commit their responsibility even towards third parties whenever they commit a supervision offence or a supervisory offence. It was an elevation of the judge to read that as meaning everything they do. It's just illogical to do so. Now, this is all the more important once one considers the development, evolution, or as my junior says, revolution, in the role of an auditor since 1942, because there is no doubt that in the 60s and then again around the turn of the century, there were onerous new responsibilities which were put on auditors. And although I think the defendant demurs, there doesn't seem in my submission to be much doubt that those are in the public interest. Now, previously, as it's described in an article quoted by Professor Slim, auditors were a cog in the wheel of the internal function. They really were just part of what the company had to do, and there was little more to do then protect the shareholders' interests. They were just there for the internal functioning of the company. Now that is patently not the case. They have been given not just these obligations, but also concomitant powers of control and investigations by the state and the central bank as time has gone on. And that includes now new duties to disclose matters to the central bank. Professor Slim goes into this in some detail, but there isn't really any dispute that auditors do have to do more today than they did in 1942. But Professor Mattar simply says in a very unconvincing section of his report that this is all part of the supervisory task. And as I say, that is simply an elision of two different things, admittedly one predicated on the other, but ignoring the common meaning, the general meaning of the word supervise and the role that the auditors have to undertake. Now, can I take you, I've mentioned a couple of times Professor Mattar's logic on this point. Can I show you how thin this was and show you how little there was on which the judge could possibly have made his finding? As you know, I say his findings were inadequate, but they certainly don't address the point, and they are in fact circular. What I want to take you to first is the second report of Professor Mattar. That starts in the right page, in the right document. It starts at page 2748 of the PDF, or on case line 02-2836, 02-2836. And the page I actually want to take you to is some pages in the PDF. It's 2797. 2797 of the PDF, and in case line 02-2885, 02-2885. Now, it's 114 and 115 that I want to look at with you. Professor Mattar, Maitre Mattar says this: in response to paragraphs 253 to 254 of Professor Slim's report, as explained in paragraphs 33 and 110, and paragraphs 211, 219 of my preliminary issues report, the alleged distinction between supervisory and non-supervisory faults is artificial and affected and does not stand up to scrutiny. In my opinion, all faults committed by auditors while exercising their audit mission, including any anti-money laundering, counter-terrorism functions, reporting obligations imposed on auditors, fall under Article 178. That is his conclusion. That's not a reason, that's a conclusion. In addition, he says, I note that I disagree that Articles 174 and 5 solely determine what are supervisory faults, and B, and this is important, the supervisory mission of auditors has evolved over time to include those tasks introduced by laws and regulations entered into force subsequent to the enactment of the Commercial Code. We agree. If Professor Slim admits that these laws and regulations are applicable to the auditor's profession, as he does, by the same token, he must accept that the tasks they encompass are intrinsically part of the auditor's supervisory mission. Well, that is a complete non sequitur. Here, Maitre Mattar is saying, if you accept that these are now things the auditors have to do, then you must accept they're part of the supervisory mission. That is presupposing the conclusion he wants to draw. Obviously, Professor Slim does accept that the role has evolved over time and that there are new laws and regulations imposing new obligations upon the auditor's profession. But he does not then logically have to accept that they're part of a supervisory mission. Quite the contrary. What he says is the mission has expanded beyond supervisory. So that sentence is a non sequitur and doesn't support the conclusion he draws. Go on in that paragraph, please. And therefore, any fault in relation thereto is necessarily a supervisory fault falling within the scope of the application. As I say, that's all a non sequitur. The next paragraph, C, says Professor Slim cannot argue that the duties and obligations of auditors have widened by virtue of laws and regulations, including banking regulation, whilst maintaining that supervisory faults are limited to those duties and obligations as originally set out in Articles 174 and 175 at the time. Either the auditor's supervisory mission has evolved and expanded or not. Well, again, this is a complete non sequitur. It is perfectly possible to say that the duties and obligations have widened by virtue of laws and regulations, and they have widened to the extent that they now have broken free of the limits of supervisory faults, if those were what was originally entailed, and now encompass something else. Maitre Matar is simply presupposing his conclusion. As for D, he says this: as we both agree that the mission of auditors as initially assigned to them in the Code of Commerce has evolved, then the interpretation of Article 178 should equally evolve. Agreed. Otherwise, the law, and particularly the Code of Commerce Board, essentially out of the uses and customs drawn from trade needs, would be static and archaic, especially so if one accounts for the slow rhythm of enactment of new laws by Parliament to accompany the ever-evolving needs of trade. In this context, Judge Elias Nassif expressly said that the task of the auditor goes beyond the accounting and administrative work to reach legal work, as they should verify the existence of legal violations. So that is simply saying, most of which we agree with, that the role has evolved and that it must be now considered in the light of the new law. That's all well and good, but there is nothing in any of this section which explains why it is that the original description of the auditor's role as supervisory has must have expanded with the increased obligations. There is no logical reason why that should be the case, and Professor Slim says it doesn't. Professor Slim says it used to be that auditors had a primarily supervisory function, but now they are also tasked with doing other things. There's nothing illogical about that conclusion, and he explains over pages and pages why that is the case. And Maitre Matar cannot impeach that logic, and so is simply thrown into saying that he's thrown into stating his conclusion and then pulling out non sequiturs such as those in paragraph B and C.
So you're not advancing a public policy. There's not a public policy argument about, if you like, the ring fencing of a certain set of things that auditors do as supervision offences covered by Article 178, and other things that auditors do that might give rise to liability under the general sort of delict provisions. Rather, it's a matter of historical evolution, that there was a time when perhaps the concept of a supervisory default exhausted the universe of auditors' liability, and time has marched on, they do other things that aren't covered by that. Is that how it goes?
Yes, exactly so. And as you can see from that report, the experts were all entirely agreed that time has marched on and the obligations, duties and powers have evolved over time. The question is whether that means that the tasks that they are now obliged to conduct have broken free of the description given to them in 1942, or whether that description somehow should be taken to have expanded as their role expanded.
Has the class expanded, or have they gone outside the class, I suppose?
Precisely. And in my submission, it's obvious. The answer to that question is obvious. It's a matter of English or French or Arabic. It's obvious that what auditors are doing today is not only much more than what they were tasked with doing in 1942, it's qualitatively different. It isn't supervisory anymore. It does have this public interest function. Obviously, the public interest function is only one that they can perform because they have a certain position as an auditor to be able to survey the operations of a company, but they are then tasked with doing subsequent actions, particularly reporting and controlling the activities of companies in the public interest for the benefit of the central bank and indeed the public in general. And there is no reason in logic why you should describe those as supervisory. It's to twist the language to do so. Now, you can imagine the situation in, let's say, 2001, when new anti-money laundering regulations were being brought in, you can imagine a legislature saying, well, hold on a minute, our Article 178 describes supervisory faults, and we have now increased the role of auditors so that they are performing functions which don't really naturally fall to be described as supervisory. And you could imagine, I'm not saying this happened or not, but you could imagine there being a debate then about whether to create some new offence in the failing to report or whether to leave it to the law as it stood. And you could imagine a system which said, well, actually, we ought to, now that we've brought new laws into place, we ought to create new offences. And you can imagine a debate about whether Article 178 covered it or not. But we don't know whether any of that happened. All we know is that no new offences were created, but new duties and obligations were certainly imposed. And there is no reason to interpret the old 1942 code ignoring the development of the role. And of course, given that you've got the background general law provision in Article 122, the Deloitte law already, then there is logic in the conclusion that auditors' functions which are not supervisory, extra supervisory functions, are ones which they have to do properly, and in default of which will put them in breach of the general law of Deloitte, as it would for anything else. And there's no illogicality in that. And we say Article 3 of the Code of Conduct actually demands that very outcome, because Article 3, as you may recall, says clearly that you can interpret, sorry, let me read that to you, in the absence of an applicable legal provision, the judge can draw upon, I'm sorry, I'm reading the wrong article, that's Article 3, I meant to read you Article 2. I've lost my reference to Article 2. So Article 2, which covers the precise the situation where there's no provision dealing with the situation in the Code of Conduct, says you take you take account of the common law provisions, which means the general law provisions. So there's no real difficulty. What happens is, if you are considering a provision which doesn't extend to the particular circumstances in question, you look to see whether there's a general common law provision. And here there is. There's no doubt there's a common law provision. So that it's not as if there's a lacuna. And this seemed to be another error that the judge fell into. He thought, well, if I don't do this, where is the responsibility going to be found? Well, the answer is the responsibility is found in Article 122, as it is with every other person. Everyone is has to comply with Article 122. You can't cause loss to another person and not be liable under the tort of Deloitte. So Article 2 demands that if an auditor commits a fault which is not supervisory, he's out with Article 178, but he still will be liable under Article 122 under the general tort of Deloitte. And it is that total failure to appreciate on the judge's part that evolution of the role of auditor, and his falling for the entirely circular non sequiturs of Maitre Matar that led into this erroneous conclusion. The other point the judge made on this, and this is the final point I need to make on Article 178, is that it was, as he put it, a tabula rasa. And he then said in his judgment, he had to give weight to the fact that there was no support for Professor Slim's view in the scholarly writings or jurisprudence put before the court. Now, this is something which the defendants put a lot of store by, and they said, well, nobody else has ever said this in any scholarly article or any jurisprudence. But as the judge appeared to accept in the course of the trial, this is a completely blank slate. There was no previous case which has considered this at all. And indeed, there is no article either which focused on the question to answer it. There are, if you like, passing comments in cases and in some of the articles which say airily that supervisory faults are faults of the auditor, but nobody has actually addressed and focused on this particular question of whether there might today be particular tasks and obligations which are imposed upon an auditor that fall out with the scope of Article 178. It simply hasn't come up. So although it might be right to say there's no scholarly writing to support what Professor Slim says, equally true is that there's no writing or judgments that contradict what Professor Slim has said. In fact, the judge below and now your lordships are faced with the situation of a completely novel position of law. And when you are faced with that, the exercise you have to conduct is to construe the law in harmony with other laws and to use your own logic and analysis to work out what the answer could be. It is not, therefore, an answer to say nobody's thought of it. It's actually simply saying no, this hasn't happened before. So the fact that there is no support is entirely neutral. It's not a negative point, it's entirely neutral. There's no support, there's no contradiction. You are left, as the judge put it, with a tabula rasa. Let me deal with the other ground of appeal on the start date. I'm conscious I've been going about 2 hours. I don't know whether it's appropriate to have a break in your lordship's hands. I won't be more than another, I certainly won't be an hour.
So I think you think we should take a 10-minute break? Judges? You can? Okay. Let's take a pause. I'm going to leave the connection here. I'll just turn off the volume. Are we ready?
I'm grateful. So let me move on to the second issue, the second ground here, where the judge erred, which is about the start point of the limitation period. I took you to Article 348 of the Code of Obligations and Contracts, and you'll recall that that says that the time limitation is computed only as from the day when the claim has become due. That is, the experts agreed, the general rule. And as a general rule, and again, the experts were agreed on this, it's the time when, at the risk of using common law language, when the cause of action accrues, when in fact the elements of the claim are all satisfied. And so in the case of a delict, that's usually in the case when the damage is suffered. We don't consider the Lebanese law of contract, but the Lebanese law of delict requires there to be fault, causation and damage or loss. And in this case, the date of the damage, we say, and it was certainly assumed to be the date, the basis of the preliminary trial, was in the middle of 2011, when the assets of LCB were sold and the company went into liquidation. That's the point when the claimants suffered their loss. We say that is the start point. Now, Article 348 and 349, which stipulates 10 years, are general principles which are obviously subject to any more specific stipulation in the codes or the statutes. Now, the experts, just to be clear, the experts were entirely agreed that there is no specific provision in Lebanese law that sets out the start date for limitation purposes of all claims against an auditor in any way, shape or form, unless Article 178 is exhaustive. And as I will show you, one of the errors the judge made was to draw his conclusion on this point based upon his conclusion on the scope of Article 178, rather than consider them as independent questions. As I said before, if it is possible that there is scope for a claim to be brought against an auditor out with Article 178, then you are left with the general law, and there is no other provision which deals with limitation by start date or period. And so it would be 10 years from the date of damage under Article 148. To put it another way, the start date issue does not arise if I'm right about the Article 178 claim. The debate between the experts on this point then was whether there was a provision, another provision of the Code of Commerce, which could be used in determining the start date. And I should have perhaps have said Article 178 mentions 5 years, but says nothing about start date. Can I get it back up on the screen in its original form? In case lines, it's 02-3685. In the PDF, it's 3573. This is the page that conveniently has the two articles we're going to be mostly focusing on, 178 and 171. And 178, as I have just said, doesn't mention when the time limit starts. It just says it's subject to the 5-year time limit. Then look at what the judge says about this. It's split over about a dozen paragraphs, starting at 157 and finishing at 169. I'll invite you to read it at your leisure, but suffice it to say that the first few paragraphs, 157, 158, 159, 160, and 161, are simply citations of various bits of authority. There is one proviso to that. Could you just take caution about 157, because the indented paragraph in 157 is not actually, as you might infer, a quote from Maitre Matar's report. Indeed, none of the words, I think, actually come from Maitre Matar's report at all. And you can see, if you read it 5 lines from the end, that it says, in his second report, Maitre Matar praised and aid the statement in Emile Tyon's work. So actually, although it's indented and in smaller type, that is, it seems, the judge's words itself. Nevertheless, the whole of this section from 157 to 161 comprises quotes from various different works by Fabien, Safar, Tyan, and others, which deal with, the judge said, this point. And it is certainly true to say that many of those, if not all of them, refer to 5 years running from the date of the General Assembly as being the start point of the liability, of time running for liability against auditors. But it is also right to say that not one of them says why that is the case. It isn't clear whether one is simply parroting or reciting the view of another, whether one was the original one and everyone else has followed suit, or whether they have all independently come to that conclusion. But you cannot see in any of them any logic for why that is the case, save that it is set in the case for directors. So all that they have done, it seems on their face, is take by analogy, the position vis-a-vis directors under Article 171 and apply it to Article 178. That's all that's happened. Professor Slim was critical of this, and you can see that in the judgment of paragraph 162. The judge records that Professor Slim was firmly of the view that the scholars whose views I have set out above would be misled by the fact that Articles 178 and 171 both referred to a limitation period of 5 years. And then it goes on to cite Professor Slim's opinion, which we advance to you today, that Article 178 is a specific provision. It can only be complemented in reference to the details relating to the computation of the 5-year limitation period by the general rules provided for in the Lebanese Code of Obligations and Contracts. It follows that the general rule provided for in Articles 3, 4, 8 and 3, 5, 6 in respect of tort claims must apply. So Professor Slim says all those commentators have been misled and read across by analogy the rule for directors to the start point of limitation when time starts to run for auditors, but without any explanation why, and all of them have been misled. Professor Slim applies a logic saying you can't do that, and that throws you back to the general rule. And Article 163 follows Professor Slim's logic. According to Professor Slim, the equivalence of the duration of 2 time limitation periods does not mean that the 2 limitation periods must be covered by the same rules related to the computation of the periods. Well, pausing there, that's obviously right as a matter of logic. The fact that Article 171 and 178 both refer to 5 years does not mean that they, the latter article 178, must be read as having a time period that starts from the same period as in 171. They just both relate to 5 years. In fact, as the experts opine, there are quite a lot of situations in the general law where specific time periods are set down of 5 years. And there's no reason to say just because it's 5 years, they must all start from the same point. So what Professor Slim says is you can't draw an analogy reading across from Article 171 that the start period for auditors is the same as the start period for directors. Now, all I've read you so far is the respective opinions of different commentators, including Professor Slim. That continues down to paragraph 166, and it's only, again, paragraph 167 and 168, where the judge actually grapples with the question and applies his own logic and describes his decision. And so I'm going to read 167 and 168 to you because they are the only points, the only critical analysis. I accept Professor Slim's evidence, the judge said, that the part of the judgment issued by the Lebanese Court of Cassation number 133 dated 17th of December 1969 set out in paragraph 16, that should be 164 above, is clear authority that Article 171 cannot be used to supplement Article 166 and the 10-year limitation period provided for in Article 349 applies to claims against directors under Article 166. Pausing there the judge is accepting that you can have 10 years as a limitation period for directors where the claims are not management claims. So you recall I showed you Article 166, which deals with fraud, but also infringements to the law and the articles. Those claims the judge here accepts would be governed by the 10-year limitation period in the general rule. The judge carries on. However, in my judgment, it does not follow from this decision that the start date of the 5-year limitation period in Article 178 is when the damage resulting from the auditor's fault occurred or was known to occur, rather than the date of the meeting of the General Assembly, when the auditors presented the report about which complaint comes to be brought under Article 178. Pausing there, strictly speaking, that is obviously right. It doesn't necessarily follow, and the judge can't be criticised for saying that strictly. It does, however, illustrate that it's perfectly possible for this to be the case, for there to be two different time periods for two different articles within the Code of Commerce for the same class of person. That is certainly what that judgment does show, but it doesn't follow that the start date should be the general one under the LCOC. But the judge explains his reasoning in my submission unconvincing terms. 2 lines up from the end of the page. I say this because there is no provision relating to auditors that is the equivalent of Article 166. Thus, dishonesty in the conduct of an audit or willful default where a blind eye is deliberately turned to misconduct by the board stands to be brought under Article 178. And it follows, in my opinion, that this decision does not affect the reasoning underlying the view that the start date referred to in Article 171 should be implied into Article 178. Now, just considering those 2 sentences, the judge is clearly building upon his earlier finding, because he is saying that dishonesty or willful default falls within Article 178. So he's basically building upon his finding that any claim against an auditor would fall under Article 178. That was the thrust of his earlier finding in paragraph 156. And he then goes on to say that it follows, and we say this is a non sequitur, that the decision, 1969 decision, does not affect the reasoning underlying the view that the start date referred to in 171 should be implied into 178. In my respectful submission, it doesn't follow at all. There are, however, 2 reasons then set out in the rest of this paragraph as to why the judge thinks that is the case. There's what I call the line running through argument, Roman 1. There is a line running through the provisions dealing with how to operate a joint stock company, directors' liability, auditors, and the General Assembly that connects all these things. so that one has to take all these things into consideration in analysing and interpreting any one article of the connected articles. Now, pausing there, it is certainly the case that what you have in this part of the Code of Conduct is 3 sections in a particular chapter dealing with joint stock companies. I showed you that in the table of contents. Section 1 is directors, the long one. Section 2 is supervisory commissioners, 7 articles. And section 3 is shareholders' general meetings, which I didn't take you to, but which is also a relatively long collection of articles. And it is certainly true that those 3 all deal with joint stock companies. The judge does not explain what he means by the line running through, but we don't demur from the idea that you have to take them into consideration in analysing and interpreting any of the articles. And we accept that there are certainly connections. But that doesn't answer the question of whether you can read across the start point from one article to the start point of a totally different article dealing with a different class of people, or on the face of it, a different type of activity. The judge gives a footnote there, 31, which is to the oral evidence of maitre matter, and I want to show you that in a second because it may feed into the judge's logic. There is then a second reason the judge gives. This is Roman 2, 3 lines up from the end of paragraph 167. The liability of the auditors is a corollary of the liability of the directors because they, the auditors, oversee, they inspect, they supervise the workings of the company. Well, again, the judge is, if you like, building upon his earlier judgments. He is presupposing that he's right about Article 178 when he says that. But even if he is right, it doesn't mean anything to say that the liability is a corollary of the liability of directors. There is no reason why, even if that is true, that means there should be the same start date for liability claims against auditors as there is against directors. After all, they are doing different things. And in fact, we say, certainly in modern times, they're doing very different things. The directors have no obligation, for example, to report money laundering offences to the central bank. 168, let me just conclude this. Sorry, I should say there's a footnote there, 42, which is also to the oral evidence of maitre matter, and I'm going to take you to that as well. Footnote 32. So paragraph 168 is the only other paragraph that contains any reasoning on the part of the judge. In my judgment on the expert evidence put before the court, particularly the views of maitre matter, the scholarly writings canvassed above in paragraphs, all the paragraph numbers are out, I should say. That should be paragraphs 157 to 161. And the judgment of the Beirut Court of First Instance set out in, or just before paragraph 113 above, under Lebanese law, the start date of the 5-year limitation period in Article 178 is the date on which the auditor's report in respect to the audit complained of was presented to the General Assembly. So what we say about this is that none of the commentators, either those cited in paragraph 168 or those cited in the preceding paragraphs I looked at, give you any reason for why that should be the date. They do all say it, I accept that. And so you could, if you were a lazy person, just say, well, all these people say it, let's just weigh up the volume of scholars that say some point and conclude that is right. But what Professor Slim has said is, well, I'm not going to accept that as being correct if there is no logic to, or no reasoning even given for how they have come to that conclusion. And if all they have done is read 5 years in Article 171, 5 years in Article 178, and concluded that because they both say 5 years, the start date must be the same for both. So they, in my submission and Professor Slim's view, ought to be given no weight at all because they give no logic. There is the same can be said of the judgment, which I'll come to, but I want to show you, as I promised, what Maitre Matter said about this.
Mr. Thompson, Professor Slim himself did not really give any reason why, it should be for a different period, for a different length of time. He just criticized this is not so, this is not so. Then what is his conclusion or reason for his conclusion?
No, au contraire, he gave very coherent reasons as to why it should be different. Just to be clear, Chief Justice, we're not here talking about the time period, although that's an
Yeah.
aspect of it. What we're talking here is about the start date.
It's to start
And
on the time. Yeah, okay.
What Professor Slim says is there is no logic to it being the date of a directors' meeting.
Understand that.
specifically
Understand that.
And he says that is specifically because you might well have actions of an auditor which are complained about that are not brought before the general meeting and have nothing to do with the general meeting. Take, for example, the obligation to report to the central bank. That's got nothing to do with the general meeting. So there is no logic in alighting upon the general meeting as a point of time, as there is with directors, because directors general meetings are the time for directors to report to shareholders. That is the primary way in which directors are held to account for companies. They're reporting general meetings. Now, in some circumstances, it's also the point in time when auditors have their duties like come to a head, where they have to present, because auditors have to present reports as well, but not all of them, because auditors, as we now know, have other duties as well. And so if their duties now encompass things that are nothing to do with the general meeting,
yes,
what logic is there starting a limitation period? Why does time start to run from the general meeting, which has got nothing to do with the auditors?
So now your contention,
but
your contention is the time should start running from.
So it's as the judge records in paragraph 162, it just goes, you're thrown back to the general law, and time starts to run from when damage occurs. I didn't read from 5 lines on, but if you read in paragraph 162, the judge says, this is Professor Slim's view, it follows that the general view provided for in articles 348 and 356 in respect to tort claims must apply, with the result that 1, where tortious conduct and the ensuing damage occur at the same time, the limitation period runs from the date when the wrongful conduct and the damage occur. 2, where there's a period of time between the tortious conduct and the manifestation of damage and consolidation of damage, the limitation period runs from when the damage occurs. And 3, when the aggrieved person was not aware of the damage that affected him, the limitation period begins to run from when the aggrieved person was aware of the damage. So those are the general rules about when time starts to run in Deloitte. And Professor Slim says that's what you have. There's no difficulty with applying those rules, and if there is no specific rule saying otherwise, and Article 178 doesn't say otherwise, then that is what you're thrown back to. And Professor Slim also says that you are driven to that result by virtue of the rules, the codified rules of construction as well, because as you recall, Article 2,
your contention is if you start running from the aggrieved person was aware of the damage, was it?
That's 3. That's Roman 3. Or if he's aware of it from the start, then Roman 2, when damage actually occurs. Effectively, if I can summarize what's said by Professor Slim, he's saying it's when all the elements of the cause of action are fully constituted. So when damage is suffered, and if that's later than when the fault occurred, then at the later date. And it is suspended if the claimant is in ignorance. I don't think we need to concern ourselves too much with Roman 3. Let's put aside the idea that the aggrieved person wasn't aware. I don't think it's critical in this case. So put aside concealment and ignorance. The simple point is time starts to run from when the damage occurred and the fault, provided the fault was at the same time or before. So when you have the fault and you have the damage and they're causally connected, those are the elements of the delict, those are the elements of the tort, and that is when time starts to run. And we say in this case that the damage is suffered when the assets were sold to SocGen, which is July 2011. And just to finish the point I was making, Article 2 of the Code of Commerce requires that outcome. And that's what Professor Slim says. He says, don't forget that under Article 2, if the Code of Commerce is silent on a point, and Article 178 is silent on this point, then you look to the common law provisions, the general law. You don't use analogy, that's Article 3. You look to the general law, and the general law has an answer to this question. The general law's answer to the question is Article 348 and 349 of the LCOC. So that being the case, that is obviously the answer. You don't get to Article 3, the codified Article 3 of the Code of Commerce, which says when there's no applicable legal provision at all, you can start using analogies in the sense of equity and justice and fairness and loyalty. You don't get to that point because you can find a provision in the general law. It's only if you can't find a provision in the general law that you need to resort to analogy. So Professor Slim makes this very clear. He says, well, it's an error to read across by analogy that 5-year rule, because this is that's a specific rule that relates to directors. 171. 178 is a specific rule that relates to auditors, and it is unjustified and an error of Lebanese law to read one across to the other, particularly in circumstances where the answer is plain and comes out of Article 348 and 349 of the Code of Obligations and Conduct. I said I was going to show you those passages in the transcript which the judge referred to in his judgment. It was day 2. Right, I'm going to have to find the case lines page. The PDF page is 957 if you're using that, and the case lines page is 02989, 02-989. And the judge expressly referred to page 102, lines 7 to 11. But can I just pick it up a little bit earlier? If you look at page 101 of the transcript, I don't know if your lordship has that. I'm nervous about advancing too fast, but the transcript page 101 at line 8. Yes. So this is Mr. Fisher, my learned predecessor, who said to Maitre Matar, I want you to actually look at above Article 144. This is in the Code of Commerce. I want to ask you about the chapter headings, but this is chapter 3 in the code. You agree? Yes. And it's headed Operations of Joint Stock Companies, and we're talking about section 1, which is headed Directors. Yes. And I wanted to establish with you, first of all, is that Article 144 through 171 are all provisions applicable to directors. 100% yes. I've shown that to your lordships as well. At section 2, which is the heading immediately above Article 171, we have a heading Supervisory Commitment. Yes, this is the second section. The second section and the third section is General Assembly, exactly, shareholders' general meeting. So they have then looked at the whole of the structure of this chapter. Yes, so this is one thing. This is how you run a joint stock company. Yes. Now, I'm going to pause before I read on, because it's from this moment that the judge expressly refers to in his judgment. Lines 7 to 13, he cites. 7 to 13, Maitre Matar says this, in my mind, it has to be that all of this conjunction together, because it is under the same basically overall umbrella chapter, how to operate the joint stock company, the director's liability, the auditors, supervisor auditors, and the General Assembly, etc. That is what the judge refers to. And in my respectful submission, it does not support the judge's conclusion that there is a line running through the provisions dealing with how to operate a joint stock company, director's liability, auditors, and General Assembly that connects all these things, so that one has to take all these things into consideration in analysing and interpreting any one article of the connected articles. That isn't what Maitre Matar says, but even if it were what he said, it doesn't provide you with an answer to the question before him. When does the start date run? It is not as if Maitre Matar said, oh, well, actually, because they're all on the same chapter, you must read them all across one from the other. He does go on to say, to be fair, I'll read on line 13. So there is a line that this, in my interpretation, that connects all of these things that you have to, that they have to be. This was my approach, that you have to take all this into consideration in analysing and interpreting any one article of the many articles that are under this heading. Yes, please. Now, that may be, but that doesn't answer the question. The other section that the judge expressly referred to is a few pages on. It's over the page on the bundle, so 958 if you're in the PDF, or 02990 in the case lines. And the judge referred to page 106, but can you have a look at 105 first? At 105 at line 8, Mr. Fisher said, thank you. We need to understand 171 to understand the question. So let's look at 171 carefully. It's a provision that deals with director's liability. Yes, it's a provision that deals with the limitation period of 5 years. It's the provision that deals with the period from which limitation is to start. Namely, it directs that the date goes from the meeting during which the directors were required to account. And it's also quite specific in saying that the directors were required to account for one particular form of irregularity, which is in relation to management. Yes. Do you agree with all that? Yes. Now, the only thing we have in section 2 is a limitation period for auditors' responsibilities where they have committed a supervision offence. That's 178. That we have in Article 178, yes, but there is no equivalent provision in section 2 that deals with the date from which time is due to run. Well, I think, are you done? Can I answer, please? Of course you can answer. I thought that you haven't when I said before that my analysis, my interpretation is as others, that the liability of the auditors is collective, and it's a corollary of the liability of the directors because they oversee, they inspect, they supervise basically the workings of the company. And therefore, to my mind, it would be effective, let me say, to disconnect them because even, as you know, if I am to take basically in an abstract manner, when the auditors in the General Assembly submit the report, okay, then if the report was flawed, the damage would start there. And this also, the damage would be basically all the commission or omission that they have covered up, let's say. In the case of the report, it would be the management that did it because it is connected. So what Maitre Matar is there addressing, I think there's probably a typo there, and he says, when he says disconnect, he probably means connect in line 13. But basically what he's saying is, you can see the connection in circumstances where there might be a report which was flawed, because that's when the damage would start. And to that point, we could see the logic, but the difficulty is that there may well be claims against auditors for breaches of things that don't sound in reports. And in those circumstances, there's no logic to the point. And the judge simply said, lifting, it seems, Maitre Matar's words, that the liability of the auditors is a corollary of the liability of directors, because they oversee, inspect and supervise the working of the company. But with respect to the judge, that doesn't engage with the question. It's extremely dubious logic and leads the judge to a completely erroneous conclusion. And that was an unforced error in circumstances where Article 2 is very clear about what you do when an article is ambiguous or silent on a point. And what you do is you look to the general law. So there is a complete answer to this question, but the judge instead used the rather twisted logic of Maitre Matar to come to a conclusion which was unjustified even on the Lebanese rules of construction. I won't take you, in the interest of time, to the further comments made by Maitre Matar in his second report on this point, but suffice it to say that that it doesn't get higher than this. There is no further logic, and my learned friend won't be able to find any logic to justify why it is that this is a sensible rule. And in fact, if you stand back, you can see that it's not a sensible rule at all, because in this circumstance where the defendant auditors failed to report on a company's lack of compliance with anti-money laundering laws, the auditor's reports ex hypothesi wouldn't have contained the money laundering supervisory functions. There wouldn't have been any information which would have alerted the potential claimant to the fact that there was a fault going on. It is an omission which is completely invisible at the point of the general meeting. So there's no logic to time starting to run from the general meeting. But it gets worse than that. There are two other even worse points. First is the claimants wouldn't have suffered any loss at the point of the general meeting. There's no loss at all. So the cause of action wouldn't have accrued. The cause of action accrues when the claimants suffer the loss, not when the fault is committed. And the cause of action is only fully constituted at the time when the claimants have suffered loss, on the facts of this case, a year or so later. So time is running against the claimants even though they have no claim. And the final reason why this is an unjust answer is that it creates a disparity between the position of an auditor and a director when they're co-conspirators. take the case that auditors and directors have conspired and fraudulently colluded to defraud shareholders or even to conduct money laundering or finance terrorists, and they have breached all their duties to the shareholders, to the central bank, to society in general. Auditors on this logic would be subject to a 5-year limitation period, but directors to 10, because directors under 166, as the judge found, are subject to the general rule, the general 10-year rule, as would be anyone else, employees or third parties who might have been co-conspirators. But the auditors uniquely have the benefit of a 5-year limitation period. There's absolutely no logic to why that should be the case. The obvious and more logical answer is the general rule, and the judge, in our respectful submission, ought to have come to that conclusion. He was bamboozled by the non-secretors and answers of Maitre Matar, and he came to an answer that wasn't unjustified when there was an obvious answer to be found in the laws themselves. Now, I'll stop.
I like that part of your submission, Mr. Thompson. I like that part of submission. You see me concentrating very hard on what you're saying. I like that.
Excellent. I hope my clients.
But you're, I think, also influenced a lot by common law, our common law. Our common law, I think.
I'm seeking to interpret all of these rules according to the Lebanese articles of interpretation. I mean, as we know, and I touched on a few times, Article 2 of the Code of Commerce does direct us how to do this exercise. I say the judge didn't follow that rule. So I am trying, I know it's difficult, but I'm trying not to bring my common law training to bear too much in this point, because I am imitating a Lebanese lawyer on these points. But I say under Lebanese law, the answer is equally clear. Just to be clear, I haven't touched upon, because your lordships rightly pushed me forward to the centre of my submissions, I haven't touched upon the inadequate reasons point. I do say, just to be clear, and it is set out in Skate, and Justice French is right, that there are inadequate reasons given by the judge for the Article 178 point in particular. We say it's a bit thin in relation to start date, but certainly for Article 178, there are inadequate reasons. The conclusion of that is that all he mentions is a construction point and no support. He's wrong about both of those, but if he gave inadequate reasons, the thing is de novo for you, and your lordships can take a totally new approach. So it may only come to an academic difference of how one approaches the appeal. But unless your lordships ask me to, I won't expand on my submissions on that. And unless Mr. Osmond tells me otherwise, I will rest my submissions there.
The international approach, as distinct from treating this as a sort of review of fact finding, mean that the distinction between de novo for inadequate reasons and just the exercise of the appellate function rather vanishes. One doesn't have to call it a question of law, but some sort of creature in the middle.
I think that's probably right. It certainly diminishes significantly at the very least. It probably becomes illusory. I think in this case, it's certainly a vanishingly small difference, because in this case, even with the English approach, I don't think you have a hugely different answer. The only small differences are it may be better to call upon Arabic speakers and Arabic readers to look at the terminology of auditors, and that's something that the first instance judge couldn't do, and which wasn't addressed specifically by him in the judgment, and also the question of whether you can just receive quay submissions all my arguments about Lebanese law. As I said at the beginning, I dare say you will conclude that the sorts of arguments you have heard and the tenor of the arguments being made by me, and I dare say Ms. Day, do sound very much like arguments about errors of law rather than errors of fact. And for that reason, I think in this case it is illusory, or at least pretty small, and in this case maybe academic. I anticipated your lordships might want to put down a general rule.
Well, we're in an area where there's a fairly fuzzy boundary, and it's interesting that there are, I think, increasing incidences of courts entering into MOUs with other courts to determine, if referred, questions of law which may arise in one court. So New South Wales, New York, for example, I think New South Wales and Singapore International Commercial Court and so forth. But anyway, we're not in that territory. We can't just write off to the Lebanese. So,
and it's part of a broader debate that's going on anyway. I think even in England, Lord Leggett has given a judgment where there's some questions about the very nature of foreign law as being adduced. So it's certainly a hot topic, but whether those more interesting, wider questions need trouble your lordships in this case, I say nothing.
Or is sufficient unto the day. Okay, thank you.
Unless I can assist you further, my lords, those are my submissions on the appeal.
Yes, Ms. Day, before you proceed, can you just sort of lay down what you're going to say? What are you going to cover? Just briefly in 3 lines, what you want to cover, in what order, so that I have my mind to follow what you're how you're going to submit.
Of course. I'm going to deal with 3 things. First of all, the general approach, and I'm going to deal with what's been submitted to you, which is in effect that you should prefer the logic of Professor Slim. And I will say that that is not a ground for appeal, whether it's fact or law. An error by the judge hasn't actually been identified in any sense. So my primary submission is you can deal with this appeal very quickly. Secondly, and without prejudice to that, I will come on to deal with the 2 points of substance. And there I will go into what the judge said in some more detail, because actually there are parts of his judgment you haven't been taken to. You are not, it is not said to you that anything's been missummarized or missed out by the judge. All that is said to you is that the logic of Professor Slim was preferable. That is not a ground for an appeal. So I'll deal with the 2 substantive points. First of all, the period, is it 5 years or 10 years? And then secondly, the time from which it runs.
Yes, please.
So as I say, the court needs to be very, very careful here. And in a way, the distinction between fact and law doesn't really matter so much. I will show you why the claimants, until this appeal, were very, very keen to say that this was an issue of fact. You will also be well aware that Mr. Justice Field is a very well and experienced, respected judge. And you will have seen that he appeared in Prativi and Fidel and the cases that you were taken to today. And one of the reasons that this has proceeded in the way that it has is because the claimants themselves, Mr. Fisher, formerly leading counsel for the claimants, actually said that this should be heard on the basis of evidence. None of us are qualified Lebanese lawyers. And if you consider, for example, the Singapore International Court, you have to have a lawyer making submissions who's qualified in the law that's being submitted. Some of us may speak Arabic, but none of us are qualified in Lebanese law. And the proposition that because you speak the language, you're then qualified to embark upon deciding what the law is an extraordinary one, which I hope the court will reject. But the important point is that only the judge saw and heard these experts over the course of 3 days. And some of the submissions that have been made today are not even supported by Professor Slim. They may be interesting, but they weren't actually what Professor Slim argued. For example, the Article 2, Article 122 issues. So one needs to be very, very careful here. This was a very experienced judge who heard evidence over 3 days, as the claimants had asked him to do. And I can give you a reference for that. It's 1B/18392. That was Mr. Fisher when there was a decision being made about whether there should be a preliminary issue, which the claimants were opposed to. But he was very, very clear that that should be heard on the basis of evidence about the parameters of Lebanese law. And that is why we went down the route that we did. So any appeal from the judge's decision must be a review of that decision. It cannot be a rehearing. And what we say you would need to be satisfied of is that either his decision was wholly unsupported by the evidence, or was a decision that no reasonable judge could have reached. And we don't come close to that. In fact, what you've been treated to for the last 3 hours is saying, well, the judge preferred matter, but we want you, appeal court, to decide that Slim should be preferred. That's not a proper role for the appeal court to perform. We do say that the case of Byers is very important. That's the recent English Court of Appeal case. That's in bundle 7D at tab 87. Hopefully somebody will give me the case line reference for that. I want to take you to paragraphs, well, if I can take you to that decision, it's 4366 in the PDF it starts at, and I'll give you the case lines reference in a minute.
Did you say 7D, Denmark?
7D for Denmark, yes. Tab 87.
Okay.
And it starts at PDF page 4366. Sorry, I'm just waiting for somebody to give me the case lines reference. It should be 02-4502.
I thought I got here 4442. 024442. 7D,
Okay.
file 7D.
Yeah, is that the case of Byers?
Yes. No, this is a submission.
Okay, so if you look in case lines, it should be 02/4502.
Okay, I got it.
Yeah.
Mark Byers and Hugh Dixon.
Yes, and this is a decision of the English Court of Appeal in January of this year. And we say this is very important because it's a very equivalent decision on the facts of what you're asked to do here. It's the best judgment to look at in terms of what the role of the Court of Appeal should be. We can see at paragraph 6 of the judgment the relevant issue that the judge was asked to decide in that case. 6(1) sets out the area of, this was Saudi Arabian law, as to the governing law of the September transfer and whether that had extinguished the rights of one of the parties. And then if we go forward in the judgment, please, to paragraph 98, where the court comes to consider the correct approach. This is a directly equivalent situation to the one we have here. It's a situation where you're dealing with a judge's findings on foreign law, where the relevant system of law is unfamiliar to the judge and the judge has heard extensive expert evidence on it. And we can see that the court sets out at 99 the general approach coming from the case of FAGE, setting out why appeal courts should be cautious in general. Then if we go forward to paragraph 100, setting out the sort of, you've got to identify an identifiable error, whether that's a material error of law or making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of the relevant evidence, or a demonstrable failure to consider relevant evidence. That's when the appeal court will interfere. We don't have any of those things here. That's a wide range of reasons why you might overturn a decision. But all that's said here is, well, the judge should have preferred Professor Slim's logic. And I'll go on to show you that that is an even more extreme submission when Professor Slim's logic isn't supported by decisions or scholars in Lebanese law. So you're asked to prefer the logic and overturn what Lebanese law actually is. And then at paragraph 101, we have the familiar warning about a trial judge's assessment or evaluation of expert evidence. And again, I reiterate to you that the judge here heard these experts over 3 days. He had the opportunity to not just read their written reports, but to hear them being cross-examined in detail on the writings, on the cases, on the logic. And obviously this court isn't in a similar position. Then at 102, the Court of Appeal quoted from another recent Court of Appeal case, again reiterating that what the appeal court's looking for is either the trial judges fundamentally misunderstood the issue or the evidence, failed to take evidence into account, arrived at a conclusion which the evidence could not support, again, some identifiable error, a material error of law, or the finding is outside the bounds within which reasonable disagreement is possible. Again, none of those identified on this appeal. Paragraph 103, foreign law is a question of fact, which the trial judge is required to determine on the basis of the evidence deployed by the parties. And that is directly applicable to this case, because in this case, the court had a discretion to treat this as an issue of fact. We went through various preliminary hearings and it was decided on the basis, I should say, of the claimants pushing this, that this shouldn't be dealt with by way of submission, that foreign law should be treated as an issue of fact. When having been through that process, the claimant doesn't like the answer that was given, it then resorts to saying this should be an issue of law. There's no appeal from the decision to treat this as an issue of fact below, and therefore any appeal must also treat this as an appeal from a question of fact. And then you will see later on, and then the next sentence is also important. The task for the judge is to determine what the highest available court in the foreign jurisdiction would decide if the point had come before it. And then we see the Court of Appeal quotes from the Macmillan case, which you've been taken to this morning. If we turn over the page. And we see at the end of that extract the reference to where the court may, if the concepts are familiar to it, apply its own judgment. If it's familiar to an English lawyer, then it can, the trial judge can form his or her own independent view. Of course, that is not the situation that we're dealing with here. And you saw at the end of the submissions the danger. My learned friend was slipping into dealing with this as if it was a question of common law, with the greatest of respect to him. The date of damage and all of those issues, he was dealing with that as if it was a common law question. And his submissions, when you look at the pleading, are submissions that were made by the claimant in relation to the DIFC law position, if in effect common law applied. The judge, of course, decided that Lebanese law applied here. Lebanese law has different provisions. Then paragraph 104, sorry, I'm not sure if somebody's unmuted, but I've got an echo.
I'm sorry, that's me, Mr. I was just wanting to query the taxonomy of fact, which may serve some purposes, but I wonder whether a court of appeal is required to treat a finding about foreign law, which has followed expert evidence, as though it were a finding about the weather or a conversation. It really is in a different kind of category, and you can see why it's treated as a question of fact because of the way it's addressed. But there's a certain awkwardness about that, and that's why I'm a little concerned about your suggestion that the appellate function in respect of a question of foreign law is defined in the same way as the appellate function with respect to a judge's finding of fact based on assessment of witnesses.
Well, I don't go as far as that, because I say that Byers is the perfect example of how you apply it, and Byers sets out that you treat it primarily as a question of fact, but with a nuance. And the nuance is, if you, as the judge, are qualified in the system of law, you can apply your own experience to the question that you're asked to decide. But what we will see in this case is the Court of Appeal were very critical of an English judge wading into dealing with Saudi law. And in that sense, therefore, the judge had to deal with this question of what the law was on the basis of the expert evidence, if that makes sense. And likewise here, the court needs to be very careful that doesn't start trying to apply its own ideas of these concepts, because none of us are Lebanese qualified lawyers. The Lebanese system is based on the French system. And as I say, the mere fact that being able to speak Arabic, with greatest respect, doesn't qualify one to be able to say what Lebanese law is. So in my submission, everyone is dependent here on the expert evidence, if that makes sense, and trying to impose one's own logic or thoughts about what Lebanese law should be is a very, very dangerous exercise. And that's effectively what you've been treated to for 3 hours this morning. And that was Professor Slim's approach fundamentally that the judge rejected. And you saw the frank admission this morning that his approach was not supported by scholars, was not supported by any decisions of the court. He had his own view as an academic on what Lebanese law should be, but the judge rightly rejected that. And it would be very dangerous for the court to wade in now on an appeal and say, well, we agree with Professor Slim.
But some of the material from the experts in this area tends to be argumentative, doesn't it?
Yes, yeah. But I think that's why Mr. Thompson was very dismissive of the fact that there's no the scholars is neutral, he says. I disagree with that fundamentally, because actually the whole point of going through all the writings and the decisions that such as they are under Lebanese law is because those are the authorities that apply. If you were to go to a court in Lebanon and try and argue these points, it wouldn't be an academic discussion of what position is more logical. You don't have the same doctrine of precedent, but you do have to show and argue that your viewpoint is accepted by scholars, etc. And in effect, Professor Slim was saying, well, everyone else is wrong and I'm right because my logic's a lot better.
Yeah, it just throws up the advantage of actually going off to the other place and asking the court. Okay, thanks.
Yeah. Well, I'll resist the cheap comment that we tried to persuade the claimants that this would be much better dealt with by the courts in Lebanon. But obviously they wish to come here and have this heard by the DFC rather than the courts in Lebanon. But if you look back at what is said in Byers, the qualification to expert evidence and foreign law, there is a qualification, I accept. But in this particular case, that qualification doesn't apply, because if you look at the second sentence of paragraph 104, it says where the foreign law is in the form of a provision of a code, statute, or other written source, the task of the court remains one of determining how the foreign courts would interpret and apply it based on the evidence of the expert witnesses. Generally speaking, the court's task is not to understand how it would itself interpret and apply the provision. The wording of the provision is to be considered only as part of the evidence and as a help to decide between conflicting expert testimony. And that's particularly apposite in this case when you're being urged to decide that what Professor Slim says is more logical, it's more appropriate. That's not the question that the judge below was deciding, and it's not the question that's for you. And then we see at the end the reference to the fact that if you have a foreign law issue where here it's the English court, but you could say the DIFC court's expertise, for example, where the foreign law is written in the English language and involves concepts similar to English law and familiar to English judges. And with the greatest respect, that qualification doesn't apply here. But quite frankly, even if it did, you should be basing your viewpoint on what Lebanese law actually is, not what it should be. And then we see at 105, the court simply said that that proviso didn't apply in that particular case because the texts were in Arabic. The trial judge had to work from an agreed translation, but also this was an Islamic system of law whose concepts and principles were far removed from the common law familiar to English judges. And then at the very end of that paragraph, this is a case in which the phage approach applies. The court should be slow to interfere with the judge's findings of fact on Saudi Arabian law and should only do so in accordance with the principles applicable generally to findings of fact made by the trial judge who has based his findings on evidence from the witnesses. But as I say, it may be that this is more theoretical than real in this case, because even if you treat this as a question of law, we have not seen here identified any error. What is said is the judge was wrong to prefer Matar, and you should also therefore overrule that and prefer Slim on the basis of logic. So in my submission, it won't actually matter to your actual decision, but we say, and we would commend the buyer's approach to you. It's a very careful and thoughtful approach. And we say that there are difficulties with, for example, saying you should import the SICC approach into the DIFC, because in the SICC, you could not have this case being argued by myself or Mr. Thompson. You would have to have a Lebanese qualified lawyer actually making the submissions to you. That's part of their rules. We set that out in our note. So it is a slightly different approach. Just finally, before we leave this case, if you look at the end of paragraph 111, and again, you will recall you've been taken to some edited highlights from the transcript here. That was something that the court specifically said the appeal court shouldn't be venturing into. And we see a transcript does not fully convey the nuanced tone and full meaning of what can be conveyed orally in the witness box. The claimant's reliance on snippets of transcript in this way was impermissible island hopping in the memorable phase of Lewis and LJ. And again, I don't want to spend time going through the transcript, but you were taken to snippets that actually do not do justice, even if you read the transcript, to what Mr. Matar was saying over the course of 3 days. He gave very long and very detailed evidence explaining to Mr. Justice Field why he believed that his opinion on what Lebanese law was, not what Lebanese law should be, but on what Lebanese law was correct. So unless the court wishes more assistance, Fidel is a very different case. As I say, that would have applied at the start when you were deciding whether the original preliminary issue below should have been heard as an issue of fact or an issue of law. The court in that case, the then Chief Justice obviously said at paragraph 73 that the court has a discretion as to how to proceed in a manner most beneficial for his education. Here, the decision was made to proceed on the basis of foreign law being a question of fact. And as we say, the approach should be the same on appeal. Again, we say Prativi doesn't assist the court here. One of the points that was made in writing was a suggestion that the judge hadn't taken account of general principles of Lebanese law sufficiently, and that he hadn't been cognizant of the fact that the laws had to be interpreted, quotes, harmoniously and so as to avoid unfair results. Before we look at the specifics, I just want to take you back to some passages of the judgment that you haven't been taken to so far. And I say it's very, very unfair and not proper to simply say that you must look only at these passages at the end of the judgment, because this judge spent a great deal of time going through all the evidence before coming to a view as to who he preferred. And therefore, you can't read certain passages in isolation. You have to look at it in the round. So if we go to the judgment, And if we can start at paragraph 40, it's 563 in the PDF. Just get the case lines number up for you. It's 02/587. So what we see is the way the judge structured his judgment is that he gave very long summaries of the evidence. There is no suggestion to you that he missummarized what each of the experts was saying, or that he missed something important out from the summary of what they said. And we see at 40 that the judge reminded himself that the last two lines, that he was to interpret the statutes in a way that they were in harmony with each other, and to ensure that the general principles and fairness were upheld. And then if we go forward to page 66 of the judgment, we see again at the end of 66, this was obviously summarizing Maitre Matar's reports, but again, the judge made clear that the judge can be guided by jurisprudence precedents and the requirements of fairness and commercial integrity. Then if I can take you next just to having a look at, first of all, at the two specific grounds of this appeal. And I should say these are all without prejudice to my primary submission, which is you don't have an error identified here that you could even start this appeal off on. And we would urge the appeal court to find that that was not set out properly. This can only be a review under any, whether it's factual or you can only be reviewing the decision below. And at points you were asked to turn this into a rehearing, which plainly that can't be right. So if we look first of all at the issue of whether it's a 5 or a 10-year period, and what was said to you in my submission quite unfairly is, well, the judge just deals with this at paragraphs 155 and 156, and therefore that's completely inadequate. And indeed, you're asked to find that inadequate reasons are given. So can I actually take you properly through the judgment that leads up to 155 and 156, because those have to be referred to in the context of what goes before, not least because they refer back to it. So if we go back to paragraph 55 of the judgment, you will see that that's where the judge starts summarizing what each of the experts said in relation to the questions on issue 2, which is the limitation issue. And for present purposes, if we go forward to paragraph 58, we see that the judge correctly, and there is no criticism of the judge, it's not said here the judge got the wrong end of the stick about what our expert was saying, he didn't understand it. The judge did understand it. It's just that he preferred Maitre Matar's evidence. And you see that the judge there properly summarizes Professor Slim's opinion, which is that the period specified in Article 178 does not apply to non-supervisory faults. And that was the point that was made. I'll come on to deal with this in a minute, but one of the problems would be a side problem, that if you were to find that there was a 5-year limitation period for supervisory faults and a 10-year for non-supervisory, which is a distinction we say just does not apply in Lebanese law, you'd have to decide within the amended particulars of claim which fell into which bucket. And that's something that's never, ever been identified by the claimants. Because it is accepted, just to remind you of this, that in relation to supervisory faults, they are subject to a 5-year period. And that's where we say actually logic is completely against the viewpoint of Professor Slim. So we see at 58 that Professor Slim's viewpoint is accurately summarised. No criticism that the judge didn't understand what Professor Slim was saying. Then if we go forward to where he summarises Mr. Mattar's views, that you will find starts at paragraph 78. And you will see there that everyone was agreed Article 78 provided for a 5-year period. Both experts were also agreed that because Article 78 was a specific provision, it displaced the 10-year period. So there was only one argument that Professor Slim was running, which was that there was some category of fault on the part of auditors which fell outside 178. If Mr. Mattar was correct and it covered everything, and we say that's clearly the position when you see the scholars and the decisions of the Lebanese courts, then this argument couldn't work. And then at 79, you will see reference to the fact that Mr. Mattar's opinion was grounded and based on the opinions of scholars. And you will have seen the reference and heard today that Professor Slim proceeded from the viewpoint that everyone else apart from him had been misled. And because his viewpoint was more logical, it should be preferred and be found to be the position under Lebanese law. And you will see then at paragraph 80, and I say the use of this word is important, that Mr. Mattar is also firmly of the view. So that reflects what the judge heard. The judge saw both Professor Slim and Mr. Mattar give evidence. He found they were both doing their best to assist the court, but he had the opportunity to test and hear how strong Mr. Mattar was in his viewpoint, that Article 178 is the sole basis for the claimant's claim. And then we see he quotes from Mr. Mattar to say that was because the claims are grounded on alleged false breaches committed by LCB's auditors while conducting their audit functions, supervisory missions. And thus all of the claims are subject to the 5-year limitation period, which period began to run when the audit reports in respect of each of the audits relied upon were presented. And then we see at 81 a specific discussion about whether Article 178 applied to the AML CTF reports. And then at 82, the fact that Mr. Mattar explained that the supervisory nature of the fault in Article 178 must be interpreted as referring to the auditor's overall mission, which is in essence supervisory. All faults committed by auditors under Lebanese law amount to supervisory faults for the following reasons. 1, the expression supervisory fault stems from the fact that the word supervision is embedded in the designation of the auditors as supervisory commissioners. 2, the auditor's mission is in essence a supervisory mission, and his liability is triggered by a fault committed in the exercise of his audit function mission. 3, fault within the ambit of Article 178 is very broadly construed by prevailing doctrine and jurisprudence so that it includes any fault committed by the auditors in the course of conducting their audit. So you will see there 3 very detailed reasons why Lebanese law said that this provision applied to everything that the auditor did whilst conducting the audit of LCB. And there's no suggestion in this case that my clients were doing anything other than conducting an audit of LCB. There's no allegation of some side conspiracy or anything else. All of the allegations in the amended particulars of claim arise out of the audit duties.
Sorry, Ms. Day. How do you respond to what Mr. Thompson said just now, that when the fault lies with the auditors, he has 5-year limitation, when it's the directors, it's 10-year limitation? And he gave an example where how the auditors can commit a fraud and then get away with it after 5 years, whereas the directors, on the other hand, is 10 years.
Well, with respect, I respond to that by saying that is the position under Lebanese law, and the fact that that might be said to be not appropriate from a policy point of view is not for us to rule on. That would be for the Lebanese courts or for the legislature in Lebanon to change it. But the problem is that when you look at all the cases and all the scholars, and you'll see that referred to in number 3, fault. And we'll see this. The judge went through all the doctrine, the judge went through the jurisprudence, and that supported Mr. Mattar's view that fault within the ambit of Article 178 was very broadly construed by the Lebanese courts. And it did encompass. One reason might be, if we want to get into the semantics, it's not as simple as it's being presented to you. For example, one of the big problems with trying to have a distinction between supervisory and non-supervisory is what falls into what category. Whereas the beauty of the rule that does apply under Lebanese law is that anything that the auditor does within the audit duties is covered by one limitation period. And we see the difficulty in that case because the claimants have never, ever identified which allegations fall into which bucket. And that's you'd expect, if this was a rule, that the court or the legislature would have to define what was a supervisory and what was a non-supervisory duty. Because as Mr. Mattar set out, in a sense, the whole point of an auditor, the auditor isn't the directors. And I should just say, because it causes some consternation on this side of the court, the suggestion that these were minority shareholders who couldn't do anything. These minority shareholders were on the very audit committees. And as you know, under auditors' law, auditors throughout the world are only the secondary layer. The primary responsibility for what happens within a company does lie with the directors. And the auditors are fulfilling a different role to that. So if we want to get into whether it's a good or a bad thing, there are lots and lots of other arguments that could be made against what Mr. Thompson said. But in my submission, the simple point is that's completely irrelevant, because what is the law of Lebanon is clear, we say. What the law should be doesn't, in a sense, doesn't matter. But if you want to go down the logic route, there are lots and lots of arguments for ensuring that the liability of auditors is clear, and that they, as professionals, know what the periods are. And secondly, that the primary responsibility for how a company is conducted lies with the directors and indeed the minority shareholders here, who, as I say, sat on the very audit committees that didn't pick up on these alleged issues. So then we go on in the judgment, before we come to the paragraphs that you were taken to. On this issue, you will see in the middle of this judgment, there's a very long, detailed recitation by the judge of various scholars, various decisions of the court. And for these purposes, if we start at paragraph 110, and this was a quote from Nassif, one of the scholars that the courts in Lebanon will use. And you will see there the extract set out that Nassif was very clear that the task of auditors went beyond accounting and administrative work to the legal work, whereby they can check whether there are legal violations, distributions, etc., or the existence of violations of the legal provisions relating to incorporation and publication. So the scholars set out quite how wide the role of the auditors is under 178, which runs directly contrary to what Professor Slim was trying to argue, which was that there was a separate bucket. And you will see in the second paragraph from Nassif that the law in Lebanon is that the date starts to run, and I will I will deal with these together because I don't want to have to take you back separately, but you will see this was one of the many scholars who said that the date started to run from the General Assembly of shareholders, and then the last sentence, the liability lawsuit lapses after the expiry of 5 years as of the date of the General Assembly to which they submitted their report. So very, very clear. And what you don't find anywhere, you don't find any scholar who says Professor Slim is right. There is this distinction between supervisory and non-supervisory, and they're subject to different limitation periods. Nor will you find, as Mr. Thompson accepted, any scholar, any case that says that the date runs from the date of damage. That's a common law concept that doesn't apply here. And in paragraph 111, you will see that what Professor Slim tried to do when he was cross-examined was he tried to say, oh, well, these are what he called classical auditor duties, and I'm going to apply a separate rule to bank auditors. And when he was cross-examined and asked about what the scholars said, his answer is telling. He said, oh, well, they've been misled by the fact that Articles 178 and 171 refer to the same limitation period. That's not a promising start either for the position the appellants took below, but even less so on appeal. And then obviously the judge records his denial that he was an outlier, but the reality is he was. As I say, you haven't had a single case, a single scholar cited to you to support the views of Professor Slim. Then I'll try and run through the ones that follow slightly more quickly. These are some of the other scholars setting out what Lebanese law is. The Treatise on Commercial Law, and that sets out the liability claim brought against the auditors prescribes 5 years since the meeting of the General Assembly that approved the report. And then Fabia and Safa, the next one, the liability action against the auditors will lapse by the period of 5 years as of the assembly during which they will have presented their report. Then Tyan, liability lawsuit against the auditors, again a reference to Article 178, provides the auditors are liable subject to a 5-year statute of limitation. And then again, the reference to the starting point being the day of the meeting of the assembly where they were to submit their report. Again, no distinction being drawn there between what Professor Slim was trying to advocate for, supervisory and non-supervisory faults. And Professor Slim, when he was asked about that, we see at paragraph 112, he tried to say, well, the judge said, what are you relying on? He said, I'm relying on Article 178 itself. And then we see the judge reciting that the mere fact that Professor Slim's argument was the same as the one you've heard today. The fact that all the Lebanese scholars disagree with me doesn't mean that that I'm not right and everyone else is wrong because I am more logical. That is not a sound basis. Then we come on to a decision of the Beirut court. So this is a court itself. The judge looked at quite a few decisions in relation to this, and you will see at the start of that quote from the Beirut court decision, you will see there that the liability lawsuit against the auditors is subject to the 5-year statute of limitation. So again, the court repeating it was a 5-year period for any claim against the auditors. And then you will see at 113 that Mr. Mattar had made the point that this decision was rendered in relation to a liability claim against the directors and auditors in the context of a company that had gone bankrupt. And you will see that at paragraph 114, that Professor Slim tried to distinguish this case by saying that it didn't involve a bank and there was no the distinction between supervisory and non-supervisory fault hadn't been raised. And then you'll see again at 115 the judge recites at length all of Professor Slim's arguments. And ultimately, the judge rejects those arguments. And we say quite rightly, because there was not a single scholar or a single decision that Professor Slim could point to show this so-called distinction between supervisory and non-supervisory fault. And then at 116, there's reference again to another judgment of the Lebanese Cour de Cassation. And you will again see there reiterated a period of 5 years for claims against auditors running from the date of the General Assembly, where members were given an account on their management. And then we see at 117 what Professor Slim said about that. So it is against that background that we come on to read what's said later on in the judgment at 155, and you can't salami slice. It's very unfair to the judge and not proper to say that the court would only look at 155 and 156. 155, the judge then recites the limitation period of 5 years, and he then considers effectively the only argument that was run by the claimants, namely that didn't apply to breaches of duty which were non-supervisory rather than supervisory. And then he refers back to some of the passages I've taken you to and refers to Professor Slim advancing those eloquently, he says, but he then says he's not persuaded by the reasoning. And he then sets out at 156 why he's not persuaded, which is in essence because he prefers Mr. Mattar's approach. And in particular, again, that's not unreasoned, it's not unprincipled. He sets out that he prefers Professor Mattar's approach because of these words, faute de surveillance, encompass any fault committed by auditors in the course of carrying out their audit function. And if and to the extent...
With, sorry to interrupt, he's dealing with the expert opinions as, in a sense, as submission, isn't he? And treating it as submission. That's why I've expressed previously some degree of discomfort with the characterization of this as fact, and I don't want to revisit that, but
No,
here
sure.
he's looking at the merits of the logic that they're using and how it fits with the language of the statute and so forth.
He's doing that, but he's also then he goes on to look at the decisions. So he doesn't stop there. It's a two-pronged, multifaceted approach, if that makes sense.
Yeah.
And also, to a degree, he is. But you will recall in one of the passages I took you to earlier, he talked about Mr. Mattar being very firm in his views. So he did also, unlike this court, have the opportunity to speak to them directly. And
people can be very firm and very wrong.
Yeah.
I've never viewed firmness as much of a guide. But,
no, but we can see, because that word isn't used elsewhere. He wanted to, in my submission, what you read into that is he was testing the veracity of whether this was something that Mr. Mattar really believed was the approach of the Lebanese courts. And that's again the important thing to remember here, that what the judge had to decide was what law the Lebanese courts would decide. He wasn't embarking on an academic exercise as to what was better. But what he does do at 156 is he sets out in a clear way why actually what Mr. Mattar was saying was the Lebanese law position. And he starts from perhaps the issue of construction, looking at the code. So I agree that might be said to be more submission. He looks at the wording of the code itself. Supervisory fault encompasses any fault committed. But of course, again, you don't read that in isolation. We've seen already he's described how fault under the Lebanese system has a very wide meaning and will encompass any fault. And that's supported by doctrine and case law. And then we see that second sentence, as Mr. Mattar observes, the word supervision is embedded in the very designation of auditors, and the scope of supervisory faults is very wide. And at this point, the judge goes to quote from Professor Slim's own report. And I want to come back to this judgment, but at this point, can I just take you to Professor Slim's report at paragraphs 90 and 91. It should be in bundle 5A. And if we can go, please, to 90 and 91. They're at 1543 of the PDF, hopefully in a minute. We will get the case lines reference. It's 02-1607. And we see at paragraph 90 that Professor Slim himself, and this is where we see the care the judge took. He doesn't just say, as has been presented to you this morning, I prefer matter on a sort of unthinking basis without detailed analysis. He actually has gone back to Professor Slim's own report and pointed out that Professor Slim's own report was at odds with what Professor Slim was saying. And we see at 90 that Professor Slim here had said it follows that an auditor can be liable under 178, where it's established that he has not behaved as a diligent auditor, i.e. where he's not abided by duties prescribed by statutory or regulatory provisions. So here, contrary to what's been submitted to you today, Professor Slim had himself, and this was part of what was examined in the course of 3 days, Professor Slim himself had said that Article 178 could encompass compliance with regulatory provisions, has avoided complying with requirements imposed by professional regulations. So again, far wider than just what he was doing in relation to the company, and then had not behaved in good faith, loyally and honestly, or has not acted prudently and diligently. And then you will see there's a footnote saying about fault. And in effect, I say that that confirmed how wide fault was. But here we have 2 specific passages of Professor Slim's report that the judge himself picked up on, which with the greatest respect meant that what Professor Slim was trying to say just wasn't right on his own analysis of what 178 covered. And then we see at 91 that he quotes from a former judge, Nassif, who's one of the scholars you'll see referred to. And you will see there again that it's a very, very wide set of duties that is encompassed, including underlined fraudulent activities or breaches of the law, etc. And then he tries to say at 92, well, that's all 178. So 178 covers it, except when you're dealing with bank auditors, and they owe some unique special duties. Tellingly, he doesn't cite a single authority, a single scholar to support that view. He doesn't cite a single case. And obviously audits happen in Lebanon all the time. The notion that you can't draw support from the fact that there's not a single case to support what he's saying is obviously wrong. You can, and the judge did, and he was entitled to do so. So if we go back to 156, after the reference to Professor Slim's report. Oh, sorry, there's one more thing in Professor Slim's report that I just want to take you to, which is actually, if you go back to paragraph 13, which is at page 1530 of the PDF. Sorry, I'm just trying to get the case lines number. You may have it already, but it's page 13. sorry, paragraph 13, 02-1594. And if you look at the first bullet point, you'll see that Professor Slim also himself accepted that Article 178 was the only specific provision within the Code of Commerce before the amendments introduced in 2019 that dealt with auditors' liability. But of course, what he couldn't show in any of the writings was that those amendments had changed in any way the rules that applied under 178. And as I say, in 90 and 91, he accepted that the very things that the claimants complain of in this case fall within 178. So then if we go back to 156, he quotes from 90 and 91, and then the judge says this: I also find that the distinction between what Professor Slim regards in paragraphs 90 and 91 of his first report as supervisory faults and the examples he gives of supervisory, non-supervisory faults is unconvincingly artificial. And again, in my submission, this court undertaking a review has no basis for interfering with that. In my submission, it's right, but that's not the question you ask yourself. There's simply no basis for the judge rejecting the distinction that Professor Slim was trying to draw on the basis of his own report. Next, he says, in addition, I think I must give weight to the fact that there's no support for Professor Slim's view in any of the scholarly writings or jurisprudence put before the court. Now, if the claimants had come here today and said to you, that was wrong, the judge didn't take account of this, and shown you something, then I can see that we might be having some kind of debate on this appeal, but they haven't. They haven't. That is right, and the claimants accept that. They say there isn't. But what they try to say, which is in my submission is a wholly unrealistic submission, is, well, that doesn't help us. It obviously helps us. It means that there was no support for Professor Slim's academic view in Lebanese law itself. And then finally, he goes on to deal with paragraphs 79 to 123 of the closing submissions, and rejects those. So he's taken those into account and doesn't find anything within that that assists him. So in my submission, we simply don't understand the basis on which this appeal even gets off the ground. And I hope that I've demonstrated that to you. If you weren't convinced, we could start going through all of these scholarly writings and the cases in more detail. But I've taken you to the ones that the judge summarised in his judgment. They're very fully set out. And as I say, the appellants don't come before you and say, he completely missed this. He summarised what Professor Slim said incorrectly. He misunderstood Professor Slim. He didn't. He not only preferred Mr. Matar, but he preferred him for, in my submission, the right reasons. But that's not what you're here to decide. So I would ask you to dismiss the appeal in relation to both grounds. I'll come on. I've just got a couple of other points to look at in relation to the date from which the period runs. I did just want to say this about supervisory and non-supervisory fault, and just to draw your attention to the notices of appeal in this case, which would put this court in an impossible position if it was to overturn the decision. If we can look, please, at the notice that's at well, sorry, first of all, can we look at there's a draft amendment, and that's to be found at bundle 1B, tab 23, page 514 in the PDF, and I'll just get the reference for you. It should be 02-530. Because the position that Professor Slim took wasn't actually pleaded either. But if you look at paragraph 326, you will see that this is a draft re-amendment that was put forward. It's at paragraph 326. In the event that the appropriate limitation is governed by Lebanese law, it's averred that. And then if you go over the page, paragraph 326.4, it says alternatively, and then in red, somebody's added, this is the proposed amendment, in respect of such of the defendant's breaches as are found to constitute supervisory faults. So the draft amendment that was put before you in relation to this isn't even a proper amendment. You'd have to give permission for it. You'd have to try and work out which of the faults were supervisory, which of them were non-supervisory. And you will see that that's repeated in the appellant's notices. If we look, please, at the appellant's notice at bundle 1A, tab 1, page 5, paragraph 13.2, which should be at 02-13. And at the last sentence of that paragraph, the judge ought to have found that Article 178 was not an exhaustive provision and did not encompass all of the claimant's claims. What does that mean? And this is really why the logic of Professor Slim actually doesn't even work, even if it was the Lebanese law. You'd have to have a way of deciding what was and what wasn't a supervisory and non-supervisory fault. There's no learning in Lebanon on that because this distinction doesn't exist. And then if you go forward to 17.1, that's repeated later on, page 10 of the PDF. 17.1, the claimants contended that certain of their claims related to supervisory faults and were brought under Article 178, but others were outside that provision. So again, we don't know what they're saying is inside and what's outside. And it's impossible to do so because you've got no Lebanese law learning on what's in and what's out. And that's part of the reason that the claimants with their large and experienced legal team have not been able to identify what's in and what's out. Can I then just deal again relatively briefly with the second point about when the date runs from? And I've taken you to some earlier passages of the judgment where this was dealt with. If we can then go back to the judge's judgment to see how he deals with this. And here he starts at 157, as has been pointed out to you. Because he hasn't dealt with this in as much detail earlier on, he goes into some more detail here. But of course, you will have seen the passages I've already taken you to, where all of the scholars, all of the case law says it starts from the date that the auditor's report is presented to the meeting of the assembly. And you will see that what the judge does is set out there. You've already been taken through this, but I say this is really, really important. This is where you find what Lebanese law is set out. And obviously it's correct that 178 doesn't say when it starts from, but we have a plethora of authority to show you when it does start from. There is no proper basis for this court rejecting that. There was none for the judge below, but there's even less reason for the court wading in here. Whatever Professor Slim thinks it should be doesn't matter, being blunt, because he'd need to show that that is actually what Lebanese law is. Professor Slim is an academic, and he obviously has some views which, as we've already debated, one may or may not agree with. An additional reason, I might add, for rejecting Professor Slim's logic is this, that it's very important that limitation periods are certain. So unlike the date damage is suffered, the common law approach, here you have a very clear date, which is 5 years from the date that that's presented. And that is a reason why it might be said to be preferable. We obviously don't get into that, but it's not the role of the DIFC to decide what the law should be. But there are good reasons why this date may have been, or this date has been adopted. So we've got a quote from various of Fabio and Safa at 157, Tyan at 158, Nassif at 159. You'll recall he's actually a former judge who was quoted by Professor Slim himself. Then we've got Seda Legal Publications, which I think is one we haven't seen, at 160. And then 161. And you will see, sorry, just in 160, that there is actually a provision again that deals with the concern that the Chief Justice raised, which is if the auditor commits a criminal offence, and there's no suggestion here that my clients have been charged with or committed a criminal offence, then there might be a different limitation period. But that would obviously be a criminal matter, not a civil matter, and would be something for the authorities to look at. Then 161, we have the decision of the court of Beirut. And then at 162, the judge sets out that Professor Slim, as we've seen in his report, says, well, all these scholars have been misled. And the judge goes to great lengths. He doesn't just dismiss that. The judge could easily have said, this is obviously wrong. The judge, in fairness to Professor Slim, goes through it and tries to look at that in detail. And then at 164, he refers to the one thing that Professor Slim had cited. And then we go on to 166. He considers Mr. Mattar's view. He then actually prefers Professor Slim's view on the issue of directors at 167, a very fair judge, no preconceived ideas. He's going through everything, seeing what he believes is the correct answer on Lebanese law. And then at 168, he then makes his decision. And in my submission, you cannot criticize the judge in any way. How can you criticize the judge? He says on the expert evidence, and in particular, Mr. Mattar, the scholarly writings, the judgment of the Beirut court, the start date is the date of the auditor's report in respect of the audit complained of. And then we see at 169, he sets out it was an agreed fact as to when the last report was presented, and therefore the claim is statute barred. So in my submission, logic can't override that. It couldn't override it before the judge, and it certainly can't override it on this appeal. So unless there's anything else that I can assist the court with, I'd urge this court to dismiss this appeal.
Thank you very much, Ms. Day. Any questions from the judges? Justice?
No, thank you. That's fine.
Okay.
Thank you.
Mr. Thompson, you have anything in response?
Yeah, I do have some things in response. I don't know whether now's an appropriate time to take a break. I think Mr. Osmond has something urgent he wants to tell me. So if I can beg your indulgence, if we weren't otherwise going to have a break.
Okay, we'll take 10 minutes. 10 minutes. 10 minutes break.
I'm very grateful. Shall I proceed?
Is Justice Shamlan here? Yeah, okay. Yes, of course, please.
Thank you. So some disparate points to reply to. I tried over those 10 minutes just to marshal them a little bit, but apologies now if they're without a lot of structure. The long and short, though, of what Miss Day seems to be saying is you should just not entertain the appeal at all because it's all perfectly good what happened below. She doesn't, with respect to her, descend to the criticisms that I have brought of the judgment in any depth at all. It's a very superficial response to this appeal. Can I take you first to a judgment of Lord Bingham, which I didn't take you to because primarily it's focused on the question of lack of reasons, but which is pertinent, just so we can see, even under the English approach, what you're here dealing with. This is the case, a very sad case of Eckersley and Binney. It's in case files at 02-4113 in the PDF 3985. It's quite a long judgment, and I'm jumping in the middle. And I'm also jumping into
I beg your pardon. 02 again, sir. 02?
02-4113. 4113. Now, this is a case of the Court of Appeal, and I should stress Lord Bingham, Lord Justice Bingham, as he then was in the minority on the outcome, but the comments he makes here about expert evidence and how they should be dealt with are ones that have been picked up subsequently and approved. And it's the final paragraph on the page, and it says this: in resolving conflicts of expert evidence, the judge remains the judge. He's not obliged to accept evidence simply because it comes from an illustrious source. He can take account of demonstrated partisanship and lack of objectivity, but save where an expert is guilty of a deliberate attempt to mislead, as happens only very rarely, a coherent, reasoned opinion expressed by a suitably qualified expert should be the subject of a coherent, reasoned rebuttal, unless it can be discounted for some other reason. Now, that is the case that we're in here. This is a case which then certainly Lord Bingham addresses the questions of inadequate reasons, but you are, even under the English approach, entitled to consider whether coherent, reasoned opinions have been subject of coherent, reasoned rebuttals. And what I stressed to you this morning, but Miss Day has not taken up the invitation to deal with, is that Professor Slim has produced a coherent, reasoned opinion which has been discarded without any coherent, reasoned rebuttal. That is, even under the English approach, an error, and allows you to permit this appeal on that basis alone. And the reason I say that is because although Miss Day took you through various paragraphs of the judgment, at no point, despite my express invitation, was she able to identify any reasoning behind the articles and indeed the judgments which the judge and she rely upon. The point is this: of course, and this is sorry, let me take this in steps. In the case of buyers, which my learned friend expressly relies upon and says is very helpful, there is that passage which I read out to you, she didn't, which says that the actual role of a first instance judge in considering foreign law is to find out what the highest court of the foreign land how it would decide that question. So that's in the PDF at 4.5. Trying to do too many things at once. 4.5.3.4. No, it isn't. That's too high. It is 4.3.9.8. 4.3.9.8, and in case files that is 02-4534. 02-4534. This is a paragraph I read you. The task for the judge is to determine what the highest available court in the foreign jurisdiction would decide if the point came before it. Now, with respect to Miss Day, what scholars say, even Professor Slim, is not the law. In a civil law country, cases that address a particular article, even they aren't actually the foreign law. They are in common law countries, but they're not in civil law countries. So if the task is to determine what the highest available court in the foreign jurisdiction would decide, you have to approach it on the basis of the codes and the statutes and the approach which the law takes. It's an exercise of interpreting and understanding what it is that foreign courts will do against the background available to you. And with all respect, when my learned friend says, as she says repeatedly, you've got to work out what the Lebanese law is and not what it should be, I couldn't agree more. Of course you work out what the Lebanese law is. Nobody is suggesting that this is a case where an academic has popped up and said, well, this is what the law says, but it's wrong, I don't like it, it should say something else. We've all read articles in the Law Quarterly Review and other places which say exactly that. The Court of Appeal got this wrong, the Supreme Court got that wrong, the law has taken the wrong turning, and they do occasionally feed into revisions to the law made often by appellate courts in due course. But that is not this case. What you're faced with is a situation where there is no definitive answer in the code, because the code is silent or vague. There is no Court of Cassation highest court decision which is clear enough to give you an indication of what it would do on this question. All there is some cases where an allied, related, similar topic has been touched upon, en passant, obiter, we would say, and the views of scholars. So the task before the first instance judge, which in my respectful submission he did not take up, is to identify properly what the highest available court in the foreign jurisdiction would do against the backdrop of all kinds of materials which are of varying weight and value. That's the problem. And so it is simply wrong, with respect from learned friend, to say, oh, the law's all totally clear, the judge got it right. She does not descend to explain why it is that those writings by academics and those obiter comments in certain cases demand the outcome which the judge came to.
But would I be wrong in concluding that if I was sitting as Judge Richard Fields, after having heard Metro Mata and then heard Slim, I put them together and I say Mata's opinion is more likely to be the law of Lebanon if such a case had come up. And he analyzed both opinion and arrived at that conclusion.
Absolutely no problem with that, provided in the process of doing that, you, the first instance judge, give a coherent, reasoned rebuttal of the one you're rejecting and a clear explanation of the one you're supporting. Now, obviously, first instance judges across the board are entitled to and required to say who they prefer time after time on expert evidence and everything else. That isn't the question. The question is, have they done that in a reasoned way? Have they taken the material before them and considered it in a fair way to come to a coherent conclusion which you can understand? And in this case,
okay, let's now assume, for the sake of your sake, let's assume that Richard Fields failed to do that.
Yes.
Failed to do that. So where do we stand? We review the whole thing again, isn't it? We have to look at the law again as you have submitted from the beginning. We sit as a court of first instance and arrive at our own decision. That's what you're saying, isn't it?
There's two routes to get to the same conclusion. And I touched upon this earlier. You could, if you're with me, say there are inadequate reasons provided, particularly on Article 178, but arguably on both points. And therefore, you look at the thing entirely fresh and consider the question as if you're a first instance judge.
Yes.
And nobody's suggesting you should remit it. Everyone says you have material. Or, which will come to the same destination, you can say there were errors made by the judge, errors in his analysis of the Lebanese law under whichever approach is appropriate, which lead you to the conclusion he was wrong, and therefore you allow the appeal on the basis of what is obviously the right answer. Now, they get to the same conclusion, but there are different routes. But can I just say, before we descend into this, my lord, I really would like to address why my learned friend is wrong to say that the answer is clear-cut and the judge came to the right answer. I didn't touch upon this, partly because I was rushing, but partly because in the question of, in the analysis of what the judges said, arguably that's less important than what the coherent answer is. But what my learned friend did was to take you through various snippets of the judgment where scholars are cited. Now, despite my invitation, I'm not surprised by this, by the way, she was completely unable to identify any logical basis for the findings of any of the scholars. Let me give you an example, although we could do this for every single one she took you to. But let me give you an example. Take let's take paragraph 160 of the judgment. I assure you, if you have the time and the staying power, we can do this with every single one of them. But take paragraph 160 of the judgment. This is a book published by Seda Legal Publications, which says, the liability suit against the auditors shall lapse after the expiry of 5 years as of the date of the General Assembly to which the auditors submitted their report, except in the case of a criminal offence. That's all you have. That's all that's cited. Now, there are two things missing from that. I don't know what's written before or after it, but there are two things that are missing from that extract. One is, how does the author of that publication come to that conclusion as a matter of construction of the code? What is it about Article 178 that leads the author to that conclusion, given that General Assembly isn't mentioned in Article 178? The other thing, which is absent from that citation, is any reason why that would logically be appropriate as a matter of justice in the context of the other laws of the Lebanon. Now, what you would expect in a reasoned scholarly article or any reasoned judgment is those things to be addressed. When lawyers say the answer to this question is X, they are expected to say why they've come to that conclusion. If I'm instructed to write an opinion, as rarely I am, I cannot just say the answer is 14 or no. I am expected to set out logically how I come to that conclusion. Now, when you have, admittedly, well, my own friend says there were a plethora of authority. I take issue with both those words. It's not a plethora. How could it be a plethora when all you've got is lots of people saying exactly the same thing? If I produced to you 10 books which happened to copy the same view all from the first one, that wouldn't be a plethora. That would be just people copying the views from others. And authority, it is not either. It is the view of scholars. So the correct question for the judge is to say, well, I see what all these scholars say, but what would the highest available court in the foreign jurisdiction do in the light of this? And the answer to that is they'd look at it and say, well, I cannot see how on earth the man has come to that conclusion. Let's look at the next one. Now, if, as I invite you to do, you look at each and every one of these, you will find the same deficiencies. And that is why it makes no sense to say Professor Slim is an outlier. He doesn't say what do these people say, because Professor Slim is uniquely the only person that has actually attempted to grapple with the logic of the questions and come to a coherent, reasoned explanation. And that is the problem here, which my own friend dances away from, saying, hiding behind the judgment, saying you can't possibly entertain an appeal because there are lots of people who said the opposite. If all the people who said the opposite are saying it without any support or logic or eye on justice, then they don't carry any weight. All of them are to be given no weight at all, and Professor Slim's opinion ought to be given more weight. And I come back to what Lord Justice Bingham said. where is, I asked rhetorically, the coherent, reasoned rebuttal of the analysis of Professor Slim? I've taken you to what Professor Mattar said. You've seen numerous extracts from the judgment. Nowhere do you see anybody explaining, least of all the judge, why it is that Professor Slim is wrong. Why is it that his reasoning is incoherent? All that is said is, well, there are lots of people who say something else. But it happens repeatedly in history and even in the law, that lots of people say one thing and they're all wrong. Or at least you cannot see that they're right. And that is the situation we are in. And it's not just a case, as my own friend said, of Slim popping up and saying, I'm more logical. It's actually Professor Slim being more logical, or actually, to go further, the only one who has attempted to apply logic and the rules of interpretation of the Lebanese codes to the provisions in question. And so, again, my learned friend completely avoided trying to engage with why it is Article, for example, the General Assembly rule in Article 171 should be cut and pasted into 178. She completely avoided trying to analyse why it is that supervisory faults should be read as meaning all faults, that supervisory, the word, should be ignored in Article 178. And that's the fundamental error in both what the judge said and indeed now what my learned friend says. There simply isn't reasoning there on which the judge could found it. There are just words that don't have reasons. I'll take you to another one since we're doing this exercise. I won't take you to all of them because it will take too long, though we could if you wanted me to. But if we take another one in relation to the Article 178 point, there is the citation at just before paragraph 113. So it's page 48 of the judgment. This is from a book by, I think it was a former judge, Edward Eade, and it reads this. So no, sorry, I take it back. It's a judgment of the Court of First Instance in 2009. And the judge says this: whereas the liability lawsuit against the auditors is subject to the 5-year statute of limitations, and this statute of limitations is subject to the same rules of the statute of limitations of the lawsuit against the members of the board, and its time limit applies to the company and to the shareholders since the meeting of the General Assembly that approved the report. Now, there is nothing at all to allow the reader to understand why the court has come to that conclusion. Why is it that the judge says boldly in that case that the time limit that applies to the company and the shareholders is that since the meeting of the General Assembly approved the report for lawsuits against auditors? Just doesn't say. You cannot see how the judge has come to that conclusion. Then read on. As for others, including the plaintiff in bankruptcy, so it's a trustee in bankruptcy, as it were, the statute of limitation applies as of the occurrence of the harmful act or as of its discovery of it had been concealed. So actually, what this judge is saying is, in bankruptcy, it's the general rule. The statute of limitation runs from the harmful act and discovery. It doesn't run from the general meeting. But even that doesn't have any particular explanation on its face of why it is said. So it isn't good enough with respect to my own friend or to the judge to say, well, look at all these passages where the thing is said. If in none of them can you see any basis for that conclusion being drawn. And a fortiori in a case where the specific issues here in question have never been focused on. Because you are here engaged in an exercise of looking at unreasoned obiter comments on issues that weren't actually before the court or have not been focused on by the academics. Conversely, these two commentators, the expert witnesses in the court below, were invited to look specifically at this point. But as I've shown you, Maitre Mattar simply used circular reasoning, assumed his conclusion, put in a bunch of non sequiturs, and just told you what he said the answer was. Professor Slim, by contrast, actually went through and analysed the questions. It's striking how much more detailed his reports are. Went in and analysed the question and explained the reasoning by which he came to that conclusion. So that's the fundamental point on which I think my own friend and I are disagreed. There were a couple of points which my learned friend took a side swipe at me, I think. Can I just defend myself on, there were three of them, on all three? Snippets of transcripts, it is right that the Court of Appeal have said they are inappropriate. But I think you will find that I only took you to the transcripts where the judge expressly referred to certain reasoning in his judgment. Footnotes 31 and 32 of the judgment expressly refer to the pages in the transcripts which I took you to, and I took you there with a view to being fair to the judge to expand as much as possible on the logic which he had used to come to his conclusion. And I said in response, in summary, that those things that are cited by the judge by reference are not actually supportive of what he said in the judgment. They might have been, which is why I took you to them, but they're not. So that's why I took you to them. So the snippets of the transcript expressly referred to in the judgment, I would respectfully submit, might be an exception even in the eyes of Lord Justice Lewison. I was then accused of having too much of a common law approach. It's a criticism that might well be well grounded given the exercise we're involved in. I should point out we do have a Lebanese lawyer as part of our team, and so I hope I'm not overstepping the mark. But in fact, I wasn't on this point. I was told by Miss Day indirectly that it was inappropriate for me to use terminology such as date from which the damage occurred in considering the tort. But I was careful, I think, only to do so in circumstances where the experts themselves agreed. I can take you very quickly to Professor Mattar's report, his first report, to make good that point. It's in the PDF, the paragraph is the page number is 22, no, it isn't. Yes, no, the PDF is 2157.
This is just responding to a criticism of your methodology on in passing. I don't think it helps us very much.
It's not just, I think, because it's a more general point, because I was told that this isn't actually the basis of the tort of delict. And I want to prove that that's actually wrong. It was said, I think, that Article 2 of the Commercial Code does not drive you to consider that the general rule on delict must apply in the absence of a specific commercial rule, and that the question of damage doesn't run in the general law from, the question of time does not run from when damage is caused. And so I'll deal with it very quickly, I promise. At 2157 of the bundle, 02-2237 of the case files, 02-2237. And all that says, this is Matron Mattar's first report. You can see that all that he is saying there, right in the middle at paragraph 1.7, is that as a general principle of civil liability action belongs to the person who has personally suffered the damage, assuming that the causal link between the fault causing the damage and the damage is proved. So the experts were totally agreed that the general civil liability action then arises from those three things: the fault, the damage, and the causal link. And the experts on that were agreed, and that, in my respectful submission, answers entirely the point about when time would run. It couldn't run from before the civil liability actually accrues itself. I am necessarily using language from the common law, but the point is exactly the same. There is one specific point, I only had two, I think, more points to make. One specific point about the difficulty in general and in this case in distinguishing between supervisory and non-supervisory faults. My friend presupposed the answer to this appeal when she made this submission, but let's assume for the purposes of this exercise that I am right, and Professor Slim is right, that there is a distinction. What my friend says is, well, that would be terribly messy because you wouldn't be able to decide which fell into which bucket, as she put it. And she bolstered that submission by complaining that it isn't identified sufficiently in the particulars of claim, and that there is at the moment only a draft amendment which sets it out at all. Just pause before we go too far down this line. If, as I say, there is a distinction between supervisory and non-supervisory faults, there may, but not necessarily, have to be a distinction at trial drawn between the two. I say may, that is because if I am right on both my grounds of appeal, that is to say on when the start date runs as well, then none of the claims will be out of time even on the 5-year rule. So in circumstances where I am right on both my main points, then the distinction is irrelevant. It only becomes relevant if I'm right about one of my grounds on Article 178 and wrong about the other. But even in those circumstances, it's nowhere near as difficult as Ms. Day says. She says, well, it's never been done before in Lebanon. Maybe it hasn't. We all know that this question hasn't been focused upon in Lebanon. That doesn't mean to say it's impossible to do it. And in fact, tellingly and importantly, Professor Slim has done exactly that. He actually does in his report give his opinion as to how these supervisory and non-supervisory faults ought to be broken down. So if you look at page 1604 of the bundle, which in case lines for your lordship is 02-1668, 02-1668, you can see that he addresses in this section of his report his views on how breaches that amount to supervisory and non-supervisory faults might be broken down. So look at the table at the bottom of the page, and then over the page what he says is, amongst breaches alleged by the claimants in the RRAPC that fall into the first category, that is to say supervisory breaches, he puts those half a dozen bullet points, and amongst breaches alleged by the claimants that fall within the second category, i.e. non-supervisory, he puts some others. And he does the same under different scenarios, he calls them options, according to what the court decides on various issues over the next few pages. So far from it being impossible, it's been done by Professor Slim. Now that's his opinion. It is quite possible that the judge at first instance, if, and it's only an if, he has to do this exercise himself, will come to a different view. That's what judges are for. Judges have to make decisions about what is recoverable and what isn't. But that isn't the question on this appeal, wasn't the question of the preliminary issue. The preliminary issue is, are all of them time barred? I mean, if the answer is no, some of them are time barred, then the judge will have to work out which is time barred and which isn't. The only point of having this preliminary issue is because there is a possibility, the judge found was the case, that all of them are time barred. And if all of them are time barred, well, we're all wasting our time. But if only some of them are time barred, well, we'll have to sift them out. And that's a matter for the trial judge. It hasn't been pleaded, it said against me. Well, I didn't have a hand in the particular claim. I'm not saying that to absolve responsibility, but it seems to me that as a question of limitation, this is something which could quite rightly only have been picked up in a reply anyway. But whether it's in one pleading or another is academic. Patently, the question can be decided. If they need to be identified in due course, no doubt they will be. That is the matter for the trial judge, not a matter for now. And it certainly isn't a basis for saying the appeal shouldn't be allowed because nobody's identified them before. They can be identified, as Professor Slim has done. Therefore, the distinction is not illusory or artificial, as the judge suggested, and therefore the distinction is available to the Lebanese courts, and in our submission ought to be made for the logical and strong reasons that Professor Slim puts forward. My final point, I think, was another point that I was going to make in opening but skirted over, which is about what the judge said in paragraph 157 about Professor Slim's paragraphs 90 and 91. We were taken to these. So it was said in the judgment at paragraph 156, the scope of the supervisory faults is very wide, as is clear from paragraphs 90 and 91 Professor Slim's first report. That is in the bundle at page 1543. In case lines, it is 02-1607. You were taken to this by my learned friend. And you can see, and she read you the first paragraph entirely, that there is a description of certain duties that would be breached and lead to liability under 178. But what the judge said is, this shows that the scope of supervisory faults is very wide. But with respect, that doesn't answer the question. The question isn't, is it wide? The question is it exhaustive? It might well be wide. There might well be many different things which fall under Article 178. But the question is it exhaustive? And of course, Professor Slim did engage with that question 20 odd pages later. So if you go to page 1565 or 02-1629, 02-1629, you can see the actual provision, the actual paragraphs in this report where Professor Slim deals with the point in issue, which is about the exhaustiveness or otherwise of Article 178. And in paragraph 206, you can see that the professor sets out in some detail the sorts of behaviours which would be outside supervisory faults. So look at Roman 4, halfway down this line. This is a summary paragraph, I should say. He goes into more detail. Paragraph 206, Roman 4, halfway down. In particular, the following behaviours can be considered as falling outside the category of supervisory faults: the breach of the duty to call for a General Assembly in accordance with Article 176, the breach of the duty to abide by the instructions of the Central Bank and the Bank Control Commission, including the instructions relating to the bank's compliance with AML CTF proceedings, and so on and so forth. And he lists out numerous of them. So whether or not you read paragraph 90 as comprising a description of faults which are wide, it is evident from this paragraph 20 pages later that he does not consider them to be exhaustive. And that's the question for the judge. So it is a non sequitur for the judge to say in paragraph 156, Professor Slim says the scope is wide, ergo they are exhaustive. That is simply illogical and cannot be supported as a finding in a judgment. The judge also says the distinction, slightly cutting across the point he's just made, is unconvincingly artificial. Well, that again is to state a conclusion without any logic. The judge had said, I won't take you to the transcript for fear of being told off, but the judge said in the course of the hearing that he understood the principal distinction which Professor Slim was making. If he understood it at the time of the hearing, he needs to explain in his judgment why by the time of judgment he finds it unconvincingly artificial. Why is it unconvincing and artificial? Professor Slim has set out the delineation. Even the judge actually tried to summarize it, albeit under issue 1 earlier, but you don't find anywhere in this paragraph or anywhere else the judge explaining why he thinks it's artificial. And again, with respect to my learned friend, I know he spent pages and pages reciting what it is that Professor Slim, Maitre Matar, and other people have said. That's all well and good. Still, the primary and most important role of a judge is then to come to a decision with reasons. And that is the failing. You cannot find a coherent, reasoned rebuttal of Professor Slim's analysis anywhere in this judgment. And you cannot say either that just because lots of other people have said something in passing, that comprises the Lebanese law. It patently doesn't. So with respect to the judge, he simply hasn't carried out the judicial exercise of analysing the expert reports and applying his intellect to them to decide how the highest court in Lebanon would come to its conclusions. Will you bear with me 1 second while I check that whether I've missed anything? Well, it's a throwaway line, but I'll say it anyway. My own friend said, if you wanted, I could take you through all the articles and all the scholarly writings and all the judgments. She didn't. I would have liked her to take you to even one where actually you could see the coherent reasoning explained, doing those two things, setting out one as a matter of construction under the Lebanese codes, how you come to this conclusion on either point, or two, setting out why as a matter of justice, that is an appropriate answer. Given that there are real difficulties with the ramifications of the conclusion which the judge made, it doesn't fall to my own friend simply to hide behind the judgment and say, this is an appeal, you should leave it well alone because there are a lot of pages in it, and there are a lot of references to what other people have said, when none of those people have said anything coherent, certainly nothing like as coherent as Professor Slim's reasoned analysis. Before I invite any questions from the panel, can I just check with those, well, that man behind me, to see whether I've missed anything? I'm grateful. So I don't know whether there are any questions from the panel on...
Any questions from the judges? Any questions?
No, thank you.
Okay. I think we have to adjourn our decision. You know, we'll come up with a decision. It's quite a lot of things to swallow. You know, it's not quite straightforward. So you have to give us time. We reserve judgment on this. But tomorrow, 4 o'clock, your other case will go on.
Yes, so that'll be, as I understand it, noon in Dubai. Is that right? Yeah.
Yes.
Certainly. And I don't know, Ms. Day may disagree with me, but I would hope that tomorrow might be shorter, particularly given the ground we've covered today. But she may disagree.
Yes, I'm sure you don't have to repeat a lot that you have gone through today. Anyway, thank you very, very much for your...
Thank you, my lord.
Thank you. So judges, we leave this link. We go on to the other link. Okay, thank you very much.